Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to a special edition of Surviving the Survivor. It's been a while since we've gotten back to the so-called Idaho 4. Tragic story. Of course, you've got... And I'm back. I'm having a little... I'm going to...
He's freezing up.
Yeah.
I should be back. You got me?
Yep.
I see you.
Right.
I hear you.
All right. What a way to start. COE, I'm going to need you in here. We got to figure out this router. It's been giving me a headache all week. But anyway, this is Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. And I was saying it has been a while since we have covered the so-called Idaho 4. Of course, it is Madison Mogen, Casey Goncalves, Xana Kernodle, and her boyfriend Ethan Chapin, all murdered before they even came close to entering the prime of their lives. So Bryan Kohberger, of course, is the accused in this case. Hard to believe this is going to be the third year come November since these crimes occurred. So time is flying by. But today, a pretty important long hearing, and there was an impromptu hearing yesterday. Tim, let me start with you, and then we'll go to Tara. You guys know Tim, criminal defense attorney out of Tallahassee, where it snowed. And then we've got Tara, defense attorney in Boise, Idaho. She travels all over the state. First off, Tim Jansen, it's kind of crazy. How much snow do you get?
We got about 3 to 4 inches, which, Tara, we don't get that here. We never get that here.
We get that in August in Idaho, but go ahead.
And then
Tim.
it got icy.
Very much.
And the roads are closed because it was like 19 last night. Some of the ice didn't melt. And people here freak out. They don't know what they're doing. We don't have ice plows. We don't have salt. We have nothing but crazy. Everybody running around, going up and down hills. And so it's been nice. In my 30 years here now, I've never seen this much snow.
Tara, do they have snow plows in Idaho?
They sure do. They have them all over the state. Yeah. It's kind of a necessity here to get around in the winter.
Snow plows in Idaho, like pigeons in New York City. But anyway,
Right.
we digress off the top. So Tim Jansen, you texted me. You said, hey, big hearing tomorrow. There was actually impromptu hearing yesterday. Tim, what are we expecting today?
Well, I saw the ABC News or maybe it's Fox News just had some defense lawyer on there saying how the state has no case if they kick out the genetic DNA stuff. And that's like the most optimistic person I've ever heard. My understanding is this IgG stuff has been challenged twice in the United States, one in Ohio and one in Washington state, and both of those were denied. So I don't have high hopes that's going to work in Idaho, but Tara may know better than I do because she's probably out there watching it. I do not believe that this case is going to be thrown out and this evidence will be thrown out.
Tim, look at this. I'm in Toronto, where, by the way, it was minus 25 Celsius. No snow, but New Orleans and Tallahassee have way more than us. So you got more snow than Tallahassee. Maybe the world is coming to an end. I have no idea. So, Tara, there's a new judge. I don't know how much you know about Judge Stephen Hippler. I was texting with Kevin Fixler, the Idaho Statesman, last night, and he said he doesn't play around. This guy is tough as they come. Do you know anything about him?
Well, I've certainly seen his decisions on different types of cases, and I would agree with Fixler on this one. I think that he's no nonsense. He's very serious. He, from what I've seen so far, has done a great job of making sure that he's administering the courtroom and keeping everybody within the time constraints that he wants, and keeping things moving forward. So, I would expect to see more of that moving forward with him.
Yeah, so I'm going to bring this up, Space Ghost, just to show everybody. This is the stream coming directly from the Boise courthouse. And you see it says this portion of the hearing is closed. It's going to be a weird day because some of the hearing is closed, some of it is open. But back to you, Tara, the portion about the IgG, and for those who do not, there you go, right on cue. That's investigative genetic genealogy. That's how they caught the Golden State serial killer. Tara, in this case, they got some sort of DNA off the knife sheath and then used IgG after covering it for almost 3 years. I still don't fully understand the whole process. But what is sort of in your that's not surprising. What in your understanding, what is going on here with the IgG, the print on the sheath, getting it from the father, all these things combined?
So to summarize the arguments on IgG, so first of all, let me take a step back. What they're doing today is called a suppression hearing. And a suppression hearing, a motion to suppress, is filed by defendants in cases. And what they're asking is that the court toss certain pieces of evidence so that they're not utilized in the case and they're not utilized at trial, because the way in which we went about getting that, or law enforcement went about getting that information, violated the law. So that's what they're doing here today. The IgG arguments, to summarize those, are basically that Kohberger's rights were violated because the way in which they obtained the information, which ultimately led to identifying him as a suspect, was obtained in a way that violated the law. So in this case, by using IgG information. And this was information that was not Kohberger's information. And this is all, allegedly, we don't have a ton of information on this right now, but this was information or DNA or IgG information that was actually a family member and ultimately led back to Bryan Kohberger. And so now he's arguing that this violated his privacy interests, and that we wouldn't have had all of these subsequent search warrants for the apartment and for Amazon and for all these other things without the IgG information that identified him as a suspect.
Tim Jansen, thank you, Tara. This comment here, interesting to me, from Michelle. The defense is really working hard for their client. It seems like they are going above and beyond. But Tim, are they also working hard for themselves? Because this is kind of a career case. If they can win this case, be a massive victory. I'm not saying that's going to happen, but is it partly because of that? Ann Taylor knows that she immediately gets put on the map. It's a payday for her in other ways if she's able to win, isn't it?
Well, I'm not going to say they're going above and beyond, because they should be doing this, right? Any defense lawyer is going to try to suppress evidence that was illegally obtained. So they're not going above and beyond. Are they trying to be creative? Do they have a long road to hoe? Yes. Do they need to keep this evidence out? Absolutely. It's interesting. They're claiming his rights were violated, but they got the genealogy of the father, right? And the question is, was the father's genealogy, was his rights, did they take them illegally? My understanding, wasn't it a trash?
Yeah, it was off.
Got off the father, and the trash, basically, when you take your trash to the curb, you have abandoned it. And I'm not going to say anybody can go into it, but you've abandoned it, take it away. Those have never been held up in Florida. In fact, drug people use those all the time to get evidence, to get search warrants. They do trash pulls, looking for drug residue, looking for paraphernalia so they can get a search warrant. So if they got the genealogy of the father from, abandoned property, I don't see how they're going to make the argument that affected Bryan Kohberger, right? It's abandoned. And if they use that information technology and trace it to him, that doesn't seem to me like a fruit of any poisonous tree.
It keeps coming up, the fruit of the poisonous tree. So Tara, just back to yesterday, this hearing was not expected. They had this hearing. The court ruled again to close certain portions of the pretrial hearings to the public. including media. There is no media allowed. So when I was talking to Kevin Fixler of the Idaho Statesman, who is probably the best reporter on this case, if I may say so myself, the media is not being allowed in to prevent, quote unquote, tainting the jury pool with inadmissible information. This is obviously, I assume, all up to Judge Hippler's discretion, but I mean, when is it the public's right to know in a public courtroom what's happening? And when is it the, I guess the discretion of the judge to say, no, in this case, the public cannot see what's happening. It seems like constitutionally there's, it's counterintuitive, but why does the judge have the say so here?
Well, because ultimately what we're trying to do, and we as a society and also the judge, is to make sure that this individual who is going to be standing trial has a fair and impartial jury and that he has a fair process. And so this is an unusual case in a lot of ways, especially for this jurisdiction. And there's been a lot of attention surrounding it. And as a result of that, I think what the judge was weighing yesterday and has been weighing, even Judge Judd was weighing, was, yes, we want hearings and we want trials to be open and public, but not at the risk of, biasing a potential jury pool with information that may not even come in at trial. And so some of this information is sensitive, like the IgG information, and information travels really quickly now through social media, all the different platforms that we have now. And so misinformation also travels as quickly as that. And the judge is trying to be very cognizant of making sure that the portions that they believe they can open to the public in a way that doesn't prejudice or bias a jury pool and have information, really sensitive information that may not be admissible at trial, go out into the world, and keeping other sections of it closed. So that's what we're dealing with this morning. Part of the hearing is closed on this IgG argument and the Franks, some of these Franks arguments, and then part of them are going to be open, and that includes, the suppression motions for, like the Amazon information and the apartment search and so on.
Mm-hmm. Just remind everyone what a Franks hearing is.
So a Franks hearing is it's a difficult hearing to get, and you're basically saying that law enforcement either lied or omitted some critical information in trying to obtain, in this instance, a search warrant for information. And it is a very high burden to even get a hearing from a court, a Franks hearing from a court. And the reason for that, I mean, if you think about it, is, warrants go through their own process, right? You have another judge who's already looked at it and signed off on the warrant and the application. And so now you're asking basically for some sort of reconsideration, like that judge got it wrong, because something was withheld or omitted or they lied. So the court will take some shorter kind of summary arguments on that to see whether he will even grant a full hearing on the issue.
Yeah. And by the way, Fix also told me that this could go very long today, possibly even into tomorrow. Tara, have you heard the same thing? Would you be surprised if this went all day?
I wouldn't be surprised. I would not be surprised if this was a 2-day hearing. There are a number of different pieces of evidence that the defense is trying to get suppressed. We've talked about some of them, but the apartment, the Apple accounts, the Amazon information, the apartment search, the pen trap and trace. There's, I think, a Google account as well. So all of those things require testimony and evidence to be put on. And so I would not at all be surprised if this was a 2-day hearing.
Thank you, Tim, to you from La Mesa up in Toronto. Tim, is garbage open season in every single state legally? By the way, I've told this story before. My friends, I didn't do this, but when I was in college, they used to go by Larry Bird's house and steal his garbage and take his shoes and all kinds of stuff. And that was way before eBay, but today I would have done that and then sold it on eBay. But anyway, I don't know if they were doing that legally or illegally, but we're going to find out from Tim right now. Tim, are there any rules about the garbage needing to be a certain distance from the homeowner's property in order to be presumed abandoned? This is going to be interesting. I mean, Ann Taylor's going to come in here with every law in the books about garbage on the curb.
Well, I can't speak for every state, but the Fourth Amendment protects people from their property and any place they believe they have an expectation of privacy, right? Expectation of privacy. What are your expectations of privacy to that property when you push it to the street and it's on the street for the purpose of being taken away? That is really one of the top things a judge looks at. And as she was saying on a Frank hearing, a search warrant is granted based on the affidavit. The judge looks at the four corners of that affidavit and can only look at the four corners of the information in that affidavit. If you believe information in that affidavit is wrong, or it was lies, or fabricated, or there was exculpatory evidence that they purposely kept out, then you can claim that that affidavit is insufficient because it was falsehoods kept out. And then you have a hearing, and then the judge will have a hearing and see if you take that stuff out or you add other stuff in. Would there still been enough information for the judge to issue the search warrant? It's a high standard. Usually the police are doing this in a quick manner. Sometimes they get information miscommunicated from another officer, and they're going to say it was not harmless, it wasn't purposeful. And so a lot of times you don't really win on a Frank's hearing. Very rarely do you hear, but it's a motion you have to make, right? As a defense lawyer, you have to make it. Information comes to you that you have to bring it to the court's attention. I see why they're doing this, because it's a death penalty case, and they would be held ineffective later on by another lawyer if he gets convicted. Why didn't you file this motion? So that's why they're doing it. I'm not going to say they're the most closed place, because when you have these hearings to keep evidence out, the purpose is to keep the jury from hearing about it, right? So if you have the media in there and people writing about it, then even if you keep it out, they're going to argue we need another change of venue because this evidence came in at the hearing, not at trial, and it's been reported and everybody knows about it. So the judge has to filter all this information and do the best a job, keep it as open as they can, and get a clean trial for both sides.
Yeah,
And
Tim, I'm going to come back to you from Purple Coconut here. After the Golden State Killer, there have been multiple cases solved, and they were admissible. The issue here is not whether IGG can work. The issue is strictly if it was obtained legally. Am I right about that?
I think that's. I haven't seen the motion, but I'm assuming you have to start at the beginning, right? You have to get the father. How did they get the father's DNA to do the IGG? Because if you start from there, the foundation, if the foundation's bad, then everything comes, the whole building is bad. But if the foundation is good, I think they lose all their argument. And I think if they got the DNA from trash can in the trash can, I think they're going to lose. Nobody believes when you put something in the trash can and push it to the curb that you have an expectation of privacy. Now, if the trash can was in the garage and it wasn't pushed to the street,
right,
they have an argument, right? Because I was just storing it there because that's a bigger storage bin than I have in the house. But when you push it to the curb, your expectation of privacy is minimal.
Yeah, and I'm almost sure that's how it went down, that it was on the curb and they went and picked it up. But Tar, to you, from Alex Reese, interesting question. How do defense attorneys, that's the funny spelling there, either Canada or the UK or Ireland, but how did defense attorneys get information or evidence suppressed without appearing as if the client is guilty? I mean, the jury would never know this, right?
Correct. And, recall that the defendant is innocent until he's proven guilty. It is the state's burden to show his guilt. So, filing a motion to suppress and saying there was illegally obtained evidence or my rights were violated is not some sort of admission of guilt. What you're saying is they didn't follow the rules here, judge or court. And you're right. If this would not go in front of a jury, that's why you have a separate suppression hearing before the trial. We're not in trial right now. We're in the pretrial motion phase. So that's how you do it.
Yeah. And by the way, this is a good point from La Mesa. This is going on right now in Long Island with Rex Heuermann, the accused Long Island serial killer. They got his DNA, which was traced back to him off of a pizza box. So obviously happening in different states. Vesper Martini, who is totally tapped into most of this, said she believes the Supreme Court ruled on garbage disposal. I have no idea what the ruling was, but that's interesting. Natalie James, for someone who was stargazing during the event, he sure argues about evidence a lot. That's a good point. Stargazing right by the house. Weird time to stargaze, middle of the night or 4 a.m, I guess. I guess that's not so weird if you're looking at stars, but where he was. But anyway, I digress again. Tara in Boise, and by the way, it's not Boise, it's Boise, like with a C in there. Is this something, we're still a ways away. It's supposed to start end of summer, I believe, in August. But are people, Moscow obviously is a different story, but in Boise, are people discussing this? Are they interested in this case? I mean, it's obviously got like international attention, but sometimes, like I talk to Tim all the time about Dan Markel and the Adelson family, which is probably one of the biggest trials ever or cases ever to, enter Tallahassee, but a lot of people don't know about it. They don't talk about it. So what's your feeling? Are people there really watching this, like, trial watching, or are they just either not interested or waiting for the action to begin in August?
I mean, it depends on the circles that you're in, right? If you're a law nerd, like I would venture to guess both myself and Tim, sorry, Tim, but I'm throwing you under the bus here. You're probably curious and interested as to what's the evidence? What are they trying to suppress? What are the legal arguments being made? I mean, I think you're always interested as an attorney on what's happening in the legal world. What are the new rulings that are coming out? Because it affects your cases as well. But, day to day, I don't think that people out on the street are generally talking about it. I think when the trial comes around and, that's being streamed, yes, of course, people are going to be watching it in the way that they watch the Lori Vallow, and Chad Daybell case. But I don't know that the ordinary person right now is, making this the center of their world. I think when big hearings like this come up, they're written about and it piques people's interest. But that's just kind of my sense right now.
By the way, Mish, how's the snow? We didn't get any in Miami. That'd be crazy. But Tim got some in Tallahassee. Is Tim surviving? Yes. Am I? Barely, because it's in the 50s. I hate it. Hence the sweatshirt. But I will have to grin and bear it for the next 2 days before it gets back into the 70s and 80s. So I know everyone feels very sorry for me. Good morning, STS. Hughes fire near me, 30,000 plus evacuated, no structures burned. God bless our firefighters and first responders. That fire ignited last night. It's windy again, but thankfully California, LA, Southern California. I heard from San Diego up to Santa Barbara is expecting rain this weekend, which will be very much needed. Look how good, not only does Tara's hair look, but Tim Jansen's hair is on point today, as always. Is the judge going to hear experts about IGG today or only use of it in previous cases? Tara, do we have any idea?
I don't know. I'm not sure. I know that there will be witnesses today. I have to confess, I didn't look deeply enough to see whether experts were going to be testifying. I would imagine they would on the IGG information. I mean, I just don't know how you get in to the kind of the part of the issue and the meat of the issue without having an expert come in and explain, to the court what IGG is and the process and all of that. So it's a guess, but yes, I think it's very likely.
Tara, even though I'm Jewish, you can always confess to me. I'll be a couple of confessions right here at STS.
I'll keep that in mind.
I'm always fascinated by confessions or going to confession. Does anyone in chat know? Have you heard of BK is in communication as his family's in communication with him in jail, I can't help but wonder. I have no idea. I've heard that they've distanced themselves. If anyone in the chat knows, let me know. And if you guys have questions, triple Qs for Tim and Tara. Again, this hearing has started in Boise, but it is portions of it are closed, and then portions of it, as you see there, the portion of this portion of the hearing is closed, right on cue. Deep Thinker Deb, thank you so much. If you do love yourself some STS, please subscribe, hit the like button. You can join our Patreon page. You know the drill. You can buy my book. That'd be great. So, Tim, one of the things that sort of struck me, which is interesting, at one point, the defense was doing everything to seal all their motions regarding genetic genealogy and
Right.
DNA, and then they asked to have it unsealed, but now
Right.
they hear behind closed doors. So what's going on? Because it sounds like the defense did like an about face and said, no, we don't want this sealed anymore. What was the strategy there and suddenly wanting to open it back up?
I think that the defense has found some avenues right to criticize the investigation, or they may have found something that they think they can use to try to possibly taint the jury in their favor. Obviously, otherwise you would always want it sealed, right? They want to use the sword, or they want to use the shield as a sword, as we call it. They found something that's positive for Bryan, so they want the hearing open. But if it's bad for him, they want it closed. So there must be something that they feel is beneficial that might help him in jury selection. And I think that's why they decided they did a turnabout face, because otherwise you would never want it out in public, or they want to have some cross-examination, or they have their own expert to tell you what kind of crazy science this is. You can't depend on it, so they can try to skew the public opinion. That's my guess.
Yeah. And Tim, again, look at this comment. In my opinion, only guilty people want this out. It's kind of akin to taking the fifth. You take the fifth, that's your constitutional right. But then if, the jury sees you not answering questions, they're like, why is this person not answering questions? But in this case, again, like I was talking with Tara earlier, the jury's never going to know whether this was suppressed or not, because they're just not, if it is, they're just never going to hear about it. Right, Tim?
No, because there'll be an order, and then the media will report that an order that certain was suppressed, and then it'll get around, and people in the community will hear a certain evidence was kept out. They don't know why. They don't know what it was. They find out. Jurors find out. People find out. In my opinion, only guilty people want this out. Not necessarily. You could have some tainted evidence that is questionable, that could be false positives, or could be tainted by, we look back to the Karen Reed trial, right? Some of that evidence was in that which should not have been in, should have been out. So every trial is different and every case is different. And normally you don't flip-flop where you want it sealed, now you want it open, right? And this judge, I'm glad Tara says this guy's a senior judge, no nonsense. That's what you need in this case. And this judge will know what the law is, and he's going to listen to the facts. He's not going to be swayed by emotions.
Yeah. Tara here from Sherry Baby. Several DNA experts have said that they think the FBI used the family tree database, which they do. They don't use Ancestry or 23andMe, but they use other ones to get the father's name. The FBI breached standards by accessing this database. I'm not sure that that's true, because I think that, again, this is how it's been done. Do you know anything about the FBI not being able to use any of these sites?
No, I mean, so that's the argument around IGG. And let me just say that we don't have part of there are pleadings and motions that have been sealed in this case, and the briefing on the IGG about why specifically the defense is asking that stuff be tossed and suppressed. We don't have that. We have the motion, and we don't have the actual memo that goes into it. But here's the thing. If you're disclosing information, there are certain instances where if you give a third party information. Your expectation of privacy, that is, the two-part analysis, right? One is, do you feel that you have an expectation of privacy? And then does society recognize that expectation of privacy as being reasonable? That analysis comes into play. And it's like, once you give up information to somebody else, you've given it up. It's out there in the world. You don't have an expectation of privacy in it. And that is some of the arguments generally around this, like IgG and the databases that are used, and sites like 23andMe, because you're giving a third party, a company, access to your information. They can do whatever they want with it. The case law, or line of case law that's often referenced in these these briefings, and it was in this case as well, is like when you're opening up a bank account, right? You're giving information about your finances to a bank. Now, it's not exactly the same because it's the type of information and scope and all of that, but same sort of idea. And that's what the argument is around, is, okay, so how did the FBI get this information? If they did get this information, was it given by dad voluntarily to a site like 23andMe? Did dad have any sort of expectation of privacy that Kohberger could try and use, which, that's a difficult argument to make. So, interesting point that's raised, good question that's raised. Not a great answer, which is, we don't know because we're not seeing the briefing on this, but that's really where they're probably headed.
Yeah. You see La Mesa pointing out this is probably true. A lot of small print on these genealogical databases. When you sign on, you sign away. But again, this is how they got the DNA to begin with. So this is going to kind of come full circle. But before I forget, by the way, this Sunday is 14 years since the death of Ellen Greenberg, who was stabbed 20 times. She was stabbed 10 to the front, 10 to the back, 10 to the back of her neck. 2 of them were post-mortem injuries. It was ruled a homicide. A few days later, it was ruled undetermined after a closed-door meeting with prosecutors and the police and the medical examiner. And then ultimately it was ruled a unaliving. It's a case that's never been investigated. In my opinion, a complete travesty of justice. We're trying to put together a show for Sunday. We reached out to Ellen's parents if they're willing to come on. It's going to obviously be a tough day because it's the day that their daughter passed away. If they don't want to do it on the day, we'll do it on Monday. But tomorrow, Scott Duffy is out of his usual slot for the next 2 weeks. So Phil Ramos, retired Las Vegas homicide detective, and Phil, F-I-L, Waters. So it's Phil and Phil. And I'm going to play them the 911 call. I'm going to give them the statement that Sam Goldberg just recently gave to CNN. And I'm going to get 2 homicide detectives' perspective on who killed Ellen. That will be, was it her or was it somebody else? So we're going to examine that tomorrow. Thank you. There you go. Prayers for Ellen Greenberg. It's a horrible story, a horrible case, and it reeks of corruption and kind of a good old boys network in Pennsylvania. Everyone's asking, Tim, if we're gonna get the hearing is going on. Someone said, when does the hearing start? It started, but people are wondering, are we going to get the information about the rulings on all this right afterwards? How do we find out about what Judge Hippler decided on?
Well, depending on the judge, I have judges who will defer ruling and issue a written ruling. You have some that will rule from the bench and then tell you that I'll follow it up with a written order. The trial's not like tomorrow, so the judge doesn't have to rule from the bench to let parties know to get their evidence in line with the ruling. So I would imagine he'll probably take it under advisement, look at the case law, read his notes, and then issue an order so that parties have plenty of time to assess where they are. I'm not sure the DNA is the only piece of evidence in this case, right? Even if some of the DNA is not kept, say that Ancestry or 23andMe do not give it to law enforcement without an authorization to do it, and they got it that way, that just takes the DNA off the sheet, right? You still have all the phone, unless they're going to say that those subpoenas are all invalid also. that's a long stretch, because there had to be some evidence that was not or didn't flow from that DNA evidence. Because I thought that they may have already figured out him as a suspect before the DNA was taken. And Tara, I may be wrong, but I thought it wasn't the DNA on the sheath that linked them to him.
I think that the defense's theory is basically that they once they identified him, Kohberger, as being a suspect, they kind of stopped looking for anything and anybody else. And the suppression motions from the defense, the ones that were unsealed that I saw, just about every single one, I think, had reference to the IgG information being the linchpin for everything else. And so they're trying to link it in that way to say, look, without IgG, there would have been, no information gathered after, there have been no arrest. There would have been no information gathered from the parents' house when they went to arrest him into the search of his space within parents' house. There would have been no, search of the car. There would have been no, on and on and on, right? I think some of the accounts, like the Apple account, for instance, or the Amazon account, was, after they had identified him as a suspect as well. And so that's how they're linking it all together. Tim, I think you're right. I think that's a hard, based on what we know right now, right? Because we haven't seen everything. We're not in trial. We haven't seen the evidence. We're just going off of some of the motions that are unsealed. That may be a really hard argument to make if there are other pieces of evidence that lead to this guy. And it doesn't, and what we do know, because it has been referenced in some of these motions and pleadings, is that, you had another roommate in the house who saw some defining features of the person that was in that house in the early morning hours. And those features allegedly matched, Kohberger's features. And so there is that piece of information, but we don't know what else is out there until, we see how this evidence unfolds at the trial.
Well, weren't there cameras that showed the vehicles at the time of day?
Yeah.
And then they found that vehicle on campus at that other campus that fit the description.
Yeah, there was the Hyundai Elantra. Yeah, and they had identified. So there was I can't remember, I think it was a convenience store perhaps that had a security camera on the external side that had caught a Hyundai Elantra. And then from there, law enforcement had said, or had used information to kind of narrow the date range of how old this Elantra was. It was like, 2011 to whatever. And they used that as well. I mean, they used it sounds like there was some sort of list of trying to find who are the registered owners of Elantras in the area, something like that, and going down that list.
Yeah. By the way, Steve Goncalves, his wife, and I maybe her sister, the daughter, will be there. They've been really vocal. Keep in mind, this is also a death penalty eligible case with a firing squad potentially in Idaho. So the Goncalveses have said very clearly out loud that they want this to be a death penalty case. So on to Amazon. There's a couple of things. Obviously, Tara mentioned them earlier on, but Amazon is one from Jamie here. He bought a K-Bar Amazon receipt, which matched his DNA, matched that knife sheath. He was in the house. His Walmart receipt bought a one-piece overall set, which is what some people said the person appeared to be wearing. Geez, let it out. Who cares? Good job, Moscow law enforcement. So, Tara, these are some of the other pieces potentially that, if the IgG is suppressed, you go to this. Not a lot of people, who are suspicious of a crime like this happen to also be buying a K-Bar knife on Amazon prior to the killing. I mean, how important is something like that?
I mean, these are all pieces of information, right? Because no one saw, as I understand it, we don't have a full face, ID of who it was that walked into this house on that evening. And so all these little bits of pieces of information, what the state is going to do is put this together and say, like, this is why we think this is the person who committed the crime. So it's important, but it's also important to remember, how did law enforcement obtain each piece of evidence that they're using this building block for their case. So for instance, on Amazon information is one of the topics for the suppression hearing today. Defense has moved to suppress the information that law enforcement got from Amazon. So they're saying that, Kohberger had a privacy interest in his Amazon account. They are alleging that the affidavits in support of the search warrant for the Amazon information recklessly or intentionally omitted critical information when it was presented to the court and to the judge. So yes, it's really great, but if it passes and gets through the suppression hearing, it can be helpful. Yes.
Another piece of this whole puzzle. Obviously, he had an apartment in Pullman, which is where Washington State is, just on the other side of the border from the University of Idaho. And Tim, law enforcement, obviously, they got warrants and went into his apartment. I'm assuming the things they got in his apartment have got to be admissible, being that they allegedly did have search warrants. Is there something that could prevent the apartment stuff from coming in?
Well, if you go back to the original problem, if the original thing that focused on him and there was no other allegation is thrown out, then they can argue that everything that flowed afterwards is a fruit of the poisonous tree, right? You wouldn't have had this if it wasn't for this. This is illegal. That taints that. You don't have to have a lot of evidence linking somebody with direct evidence. Circumstantial evidence is sufficient. And sometimes circumstantial evidence cases are stronger than eyewitness testimony. When I had the FAMU bombing case in 2000, they had an individual buying the pipe bomb, and they had a truck at certain locations, and that made a very compelling case. And they ended up convicting him. They had no eyewitness testimony. They had some search warrants at the house, and they found some things, but even if parts of this are maybe kept out, I still don't believe that they're going to have enough to kick out enough that they won't go forward. But can you imagine if they do kick it out, a motion suppress because it was illegally obtained, and the charges are dismissed, what the community would do if the evidence and the state drops the charges? Now, by law, that has to happen, but could you imagine what the uproar would be?
It would be wild. I never even thought about it. And I don't think people would feel safe if he was still in the area. And wherever he went, I don't think people would feel too safe. Ironically, there have been no murders. Nothing's happened since he's been incarcerated. Not to say that that's necessarily a surefire sign, but it's something. Tara, people were asking earlier, are lawyers required? Like, do you have to take continuing education to be able to learn about new developments in the law, like IGG, to be able to go into court and know what you're talking about?
Well, there are rules of ethics that lawyers have to follow, and one of them is that you have to be competent. And in order to be competent or to competently represent people, you need to be up to date on, as we kind of talked a little bit briefly, being a law nerd a little bit on and being aware of what's going on in the legal field. So continuing education is required. You have to do a certain number of credits in every state to keep your license to practice law. Do they specifically require something on IGG? No, that's kind of left to whatever field you're practicing in. But, if you're in the world of criminal defense like this, or a prosecutor prosecuting types of cases that may involve IGG, you should be taking continuing education credits on it, and you should be doing what you can to educate yourself on the new technology.
Going totally out into left field, having nothing to do with this. It's always a slippery slope. Everyone knows I was madly in love with my puggle, Mabel Rose, my beloved puggle of almost 17 years. She passed away a week or so before her 17th birthday. But I was with her at the vet all night until I finally went home at midnight or so. And then when I went was going to go back in the morning, I got a call that she passed away, and it still haunts me, of natural causes. But anytime someone in the chat would come in, like there's Mabel from the UK or Mabel from Mexico, I would tell them how much I loved their name because my dog was named that. And then sometimes it'd be weird because you're like, oh, it's my dog. But look at this. My dog is named Tara. Great name. Tara, how do you take that? You're a dog lover, so are you okay?
I
with
am.
that?
Oh, I am totally okay with that. My dog's name is Tequila, so that's, yeah. And she flunked out of service dog school. We probably make a great pair.
I'm not sure if Tim just rolled out for a second, but his screen just. Oh. Tim, you there? I'm looking at your ceiling.
You know what? Okay. Yeah, something happened.
There you are. You're back.
My office, yeah, this one is not too good. I got this thing that sits on top of the computer. It's not the best.
Yeah, well, I had the same thing, and I have the same problems. I have a lot more problems, actually. But Tara, what's the deal with Amazon? What are they looking? I mean, with Apple, what are they looking for with Apple?
On the suppression hearing for Apple, they're taking a couple of issues with it. They are saying that initially there were some subpoenas that were issued, and I think there were grand jury subpoenas that were issued for the information first, that it should have been a warrant. They are also arguing that the application for a warrant included kind of a copy paste job from what they used in the subpoena originally, and that shouldn't have been done. It should have been a warrant only. They're also trying to argue that the warrant was too broad. So what they were requesting of Apple wasn't specific enough in that warrant application. And so, and there's some case law to suggest that if you have an overly broad, scope on your warrant, that's not kosher, that's not lawful. And I think the other argument, and I'm doing this off of memory, so I think the other argument was that the Apple information was received around the time, or it was as a result of an iPad that was found in a common area in the parents' house during the initial search. So there seems to be multiple areas of or issues that they're taking up. Or will be taking up in the suppression hearing. I'll be interested to see what that looks like in the hearing today.
Yeah, again, if you're joining just now, Bryan Kohberger's hearing is going on, but parts of it are closed and they're not streaming certain parts. Obviously, you will see the courtroom appear when they are streaming. Just going back to Tara on this, and I have a question for Tim, and this might be a while. So if you guys have questions, triple Qs, and I'll bounce back down to the bottom of the chat in a minute. But from Lee T here, for those who don't know, there was this Reddit thread, and I barely know what Reddit is, and it was a guy named Papa Roger, and it looked exactly like, it was like a silhouette profile that looked a lot like Bryan Kohberger, and this person was revealing a lot of information that people thought only maybe investigators knew about. So the question is, could the Papa Roger Reddit account with the profile pic drawing that's Kohberger, be admitted to evidence if a civilian took the screenshots before it was deleted? This is complicated, I think, but Tara, could we hear about Papa Roger in the trial potentially?
Maybe. You have to, so with every piece of information, it's like the best lawyer answer ever. Maybe, perhaps. Yeah. Could be. But yes, but with every piece of evidence that you're putting forward in trial, you can't just go into trial and say, here's a piece of evidence. You have to lay what's called foundation. So you have to, whatever you're wanting to admit, first of all, it has to be relevant to whatever we're talking about, whatever the charges are here or the defenses are. And then you have to go through a series of steps to make sure and provide a basis that this is, what we say it is, it's authentic, that there's no funny business about it. There's no questions as to whether it's fake or not. And then you have to tie that back into, and this was Bryan Kohberger's account or handle. So a screenshot alone is not going to be enough to get that piece of evidence in. You would have to somehow link, this handle with him. And you would probably have to do that through like multiple people.
COE, just let me know. Here's Steve Goncalves and his wife. Let's listen to this. This is them talking about the case, obviously.
Come out. What happened? What happened that fateful night to our daughter?
Yeah.
And her best friend as they were, in their bed. What happened?
Yeah.
Why?
You can't seal
Very
everything
dark.
and ask the public to be a part of the case. At one point, you gotta stop sealing, and we've heard some of the Hippler's comments saying that not everything should be sealed that has been sealed, and we look forward to those things being brought to the public's attention because the public needs to agree that everything's being done the way it should be done.
Wow. I just cannot imagine what they are going through. I'll tell you that. I don't think anyone can. Tim Jansen, to you, to bring this back up, does the panel, Tim, think that the death penalty has heightened judicial rulings being pro-defense in this case because it's such a severe charge? Does the judge sometimes, I don't know, maybe knowingly or unknowingly lean in favor of defense motions because, again, the gravity of the charge?
Well, he's not going to lean in favor, but he's certainly going to have a hearing, probably issue a written ruling and collect evidence on all of the hearings and motions, preserve the record down the line because he knows there's going to be appeals. There's going to be ineffective counsel. There's going to be attacks all the way up to court, maybe up to the Supreme Court of the United States if he gets the death penalty. He's going to want to make sure he did everything properly and rules properly. It's like the Super Bowl for a judge, right? It's like, this is very serious, not a DUI case. It's a death penalty case. I don't know how many Idaho has, but it doesn't seem to me Idaho probably has a lot of death penalty cases, not like, unfortunately, Florida and other states that have crimes that really warrant it, or at least are eligible for it. So I think it is probably heightened to the courts. And like in our cases, we got cases where possible death penalty or life, you get a court reporter comes in for every hearing. Otherwise, they do it on a transcription. But if it's a serious case, the actual court reporter comes in and she's typing everything that's said and done, which you don't get in regular case management for robberies, rapes, and stuff like that.
Sorry, I was late. Do we know what time the hearing started, Buttercup? You're looking at it. The problem is part of the hearing is closed to the public. So we are at the, I don't know, we're at the mercy of court here about what they're going to, we don't know how long. This could be another hour. It could be another 5 minutes. There's just no way to know. I agree with this, that the Goncalves family is inspirational. Kaylee and her friends are going to get justice, and their family will see it's done. It's going to come very close to the 3-year mark, assuming this trial actually kicks off in the summer. Tara, what about that? I mean, do you think that this trial, it's supposed to start in the summer? It appears to be on track. What's your gut telling you? Do you think it will begin then?
I do. I think that, like I said, I think the judge has done a really great job of moving things along and making sure that things are happening on a timely basis. Obviously the sides are still in the kind of pre-trial motion phase. There's probably some discovery that's still being exchanged between the parties, but I don't see anything showing that this is not going to be on track for the trial as set.
And I'm planning to be out there. My man Tim Jansen was even talking about coming out for a part of it. So
when is the trial scheduled?
Tim, you got to come out so we could take Tara out for a drink.
That sounds great.
August. Yeah. To get a permission slip from the COE, of course. But here are the victims. You're looking at Ethan on the left. His mother's spoken out. His mother wrote a book. Kaylee, you just saw her parents. Xana's mother has spoken publicly, her family. And Madison Mogen, I don't know that I've heard much from her family. If they've spoken out, it is quite possible that that's happened. Tara, there was the apartment, Apple, Amazon. You mentioned something else that I wasn't really familiar with that's going to come up. Do you know what that is?
So they have a lot. I actually just pulled up their filings so I can read it off because I can't remember every single one off the top of my head.
Please.
But they had so there's suppression motions on Amazon, the apartment, so Kohberger's apartment, Apple, the arrest warrant, the AT&T warrant, which there was I think more than one, and this is the first one. The cell phone data, Google information, the pen trap and trace. It says person in Idaho.
That's what is the pen trap and trace? I don't know what that is.
So it's a surveillance device, and it records phone numbers that are either received or they are dialed. And then they've got person Idaho, person Pennsylvania, the white Hyundai, and the 119 Lambsden statements. So they've got a number of different issues today and tomorrow, which is why I say that this is likely going to, I would not be surprised at all if this is a 2-day hearing. So
yeah, after hearing you rattle that off, I'm like, I have no doubt this is probably going a long time. COE, if this happens to go all day, this is going to be our evening show. So I'm not sure if Steve's listening right now, but we'll bring this to you all day today. And then tomorrow I have to figure out because Phil, F-I-L and P-H-I-L, 2 homicide detectives, are going to be here at 12:30. This is definitely true from Nikki Cuds, beautiful kids, great, such a great life to live, just terrible. I mean, it's really beyond comprehension. I mean, imagine raising these kids, and then you pour your heart and soul into raising these kids, and then this happens. It's like, how do you can't, I don't know. It's just incomprehensible. Tim Jansen. So Tar just gave us other things. The arrest warrant.
Yeah.
What could be a problem there? I mean, what is the defense going to say that they misspelled there and therefore it needs to be thrown out? What's going to be the issue there?
Well, what they're going to say is if they win these other motions, right, the evidence, some of the other evidence that was collected to get the warrant for the arrest were tainted and should not be admissible. And without that evidence, there would not be enough for the warrant for the arrest. So they're going to go piece by piece. Then they're going to try to get the whole sandwich thrown out. And that's their goal. This hearing could take easily a couple of days. I mean, we might not even see anything on the screen all day long today. Or it could be later in the afternoon or tonight that we'll get some rulings or some things that are not under seal.
I don't know if the COE mutes me every once in a while. It just automatically mutes me. It must hate me. But I was saying it'll make for really good YouTube viewing if it's a blank screen all day. We can sit here and just watch this all day right here. Be very meditative. You just watch that. This portion of the hearing is closed. You could just keep saying it to yourself over and over.
Motions filed under seal, all of them?
No, not all of them. The only one that was filed under seal was the IGG information. The rest of them were open. And then I think they also have, and I failed to mention this, the defense had filed a motion to compel as well, and make the state comply with what they're saying is a prior discovery order. So that is also on the docket for today and tomorrow.
From Grateful Glow here, 1111. Tim, isn't it odd that the mentioned motions to redact are so numerous, the ones that Tar just listed off? Isn't that sort of an admission that if those were allowed, that it would sincerely help the prosecution? Why so much non-admissible? And Tim, also, you said if maybe like they're able to suppress one, they can suppress all, but isn't Amazon different from the apartment, which is different from the AT&T stuff, which is different from the cell phone?
It depends what information is used. Now, if you're in a small town and you've got someone inexperienced and they keep using the same tainted information to get other avenues and other evidence, that same taint goes to each piece. But you would think the people working on this case a murder case of this degree, that they have the experience, that they're working with the state attorney, approving everything, going over everything, dotting everything. You probably has the most experienced people working on this case, that they would have realized and know what they're doing, right? The lowest level drug cops know how to do a trash pull on someone's home. I mean, it's pretty obvious they know what they're doing. They do it a couple times. They figure out how to do it, make sure it's legal. This IgG stuff with this 23andMe, or will you give your DNA? It all depends what the language was. It depends who filled it out, who signed it. Did he do it, or did his wife do it? Did his wife give it to him for Christmas? And did she sign something waiving all that? I won't say that they know they don't have emotion, because sometimes if it's 50-50, or even if they know they're not going to win the motion, on a death penalty case, out of caution, they're going to file it anyway. And if they lose, this is a discovery for them. This is a free deposition. This is free discovery. They can get a prelude to look at the evidence before the trial, so they can tailor the defense. So it's a win-win for the defense, and it's agonizing for the prosecution, time-consuming, and I'm sure they're worried about all this stuff.
By the way, this hearing did start an hour ago. We have talked for 1 hour and 1 minute and 39 seconds as we're waiting for the open portion of the hearing to begin. But you heard Tim say it could be a while till we get there. So we're going to take a few more questions. Tara, do you have to jump? You have to jump at the top of the hour, don't you?
I do. I should probably get going here now. So,
all right. Well, thank you. Love having you, as you know. And if you want to bounce back in, if it's actually happening, we'll be here.
Okay. Sounds good. Thanks, everybody.
All right. Thanks. Don't work too hard. Thank you.
Yeah.
So Tim, from Truth Exposed here, Ann Taylor is just trying to weaken the case enough so that the prosecution will offer a plea deal. If she gets the death penalty off the table, she wins. Even if he pleads to life without parole deal, she wins. Do you agree with that?
That is absolutely true. What does a lawyer with a death penalty case want? They want anything but the death penalty. Anything but a death penalty is a win. Now, she may be thinking she's going to get more than just death penalty up the table. She might get a plea to a certain time of years. I don't believe this family would ever agree to anything but the death penalty. I don't think the state would move forward against the wishes of the victim's family, because it's a high profile, it's a multi-murder. It was planned, clearly was orchestrated to cover up the crime, and it was thought out, it was premeditated. They're going to go to the death penalty no matter what. I don't see them dropping to life. If they did, that state attorney would be thrown out of office immediately.
Where was this comment? I just saw someone says, here, Purple Coconut. Kohberger wants to go to trial. I agree with that. So, I mean, Tim, it's a win for the defense, but I guarantee you, Bryan Kohberger, if he had to plead a life without parole, is going to feel like he lost. So,
he wants to go to trial. He wants to prove to everybody how smart he is. He wants his name fixed forever. He had to know. Now I'm saying he had to know. He's innocent until proven guilty, but clearly the evidence is all pointing at him in his direction. The description that the roommate that survived gave fits him identically.
Yeah, the eyebrows.
Yeah, the eyebrows, the stature, the height, the car going back and forth, stargazing, which is foolish, turning his phone off, turning it on, going by the crime scene the next morning. All of that is very incriminating, that he had some involvement in this crime.
Yeah. You see here, this Bill Thompson, the DA in Latah County, said there would be no plea deal. He said it very early on. I mean, things, I guess, are always subject to change. You're looking at pictures of Casey Goncalves, and she's with Maddie in that bottom middle to the left there. it's tough to look at these pictures because you know how it all ends, and it's just so unfair to the families and the parents. So Tim, Tara mentioned you've got a cell phone issue coming in, but you've got AT&T. I'm not sure the difference. I don't know if one is like a Wi-Fi issue, and then you've got this Google issue, pen, trap, and trace, which I'd never even heard of, and then the Hyundai. Of these, of like the cell phone, the Wi-Fi, Googling, the car. What do you think is, I don't know, most critical to the prosecution, and what the defense would want, gone aside from the IGG?
So this is a good time to educate you and the people, okay?
Yeah, please.
A pen, trap, and trace.
Yeah.
That requires the least amount of intrusion. That is what is used by law enforcement. The feds use it a lot, almost all the time. And they do that before they try to get a wire, right? Judges don't like to put a wire up unless you use all other techniques to identify and get evidence to get that wire. So you either have cooperating participants, you do trash pulls is another place. If you identify a home that is dealing drugs, you see activity, they'll do trash pulls. You identify cars by tags, right? You get the tags in cars and you see who's coming all the time, who's going all the time. You still don't have enough for a wire, right? So what the next step would be do a pen, trap, and trace. You identify an individual you think is selling drugs. You identify that person, you get a warrant for his cell phone number. You put a pen, trap, and trace on that phone. What that does is every person that calls in and every person that calls out is identified. So then they can identify people. And then later, if they move forward and say the investigation stalls, a camera doesn't work, you can't get an undercover in there, then they will do what's called a wiretap. And you'll see that's what happened in the Markel case, right? They tried all those other investigative techniques and they ultimately did the wire, right? Where the agents did the wire and they did wire their phones. And if you remember, they tried to throw out the wire as being old and the information wasn't up to date, and they lost that. But the pen, trap, and trace is a mechanism to identify suspects, but it also can identify who's calling whom at a certain time, how long the call was for. They're great investigative techniques, very low risk to law enforcement, and you can gather quite a bit of information. So hopefully that's helpful to people to understand.
Yeah,
a wiretap is the hardest thing to get. Judges don't like to give them. You usually get them for 30 days. You have to do a lot of stuff in there to ferret out conversations that are not admissible. You have to, if it's not you got to turn it off. You put independent people in there that just sit and listen, and they ferret out so the prosecution is not hearing things they shouldn't hear.
I mean, Tim, this obviously, of all the cases we talk about, is probably the most high profile, this and the Long Island serial killer, in terms of like a broad audience. So, and this judge is tough. How important, I mean, we all saw what happened with the OJ, other high profile cases, Menendez, there was a mistrial. What does he have to do to keep this from becoming a circus-like atmosphere?
Well, you have to have a judge who's confident, who's experienced, and is not going to get caught up in the hysteria or the limelight. Judge Ito did. He got caught up in the flamboyancy of the lawyers, and he went off the rails. It might have been his judicial philosophy also. He was more defense-oriented than a prosecution. And so if you got more like a law enforcement, like this is like if you had Judge Hankinson, right? Judge Hankinson is a very, solid. He was by the book. He was a prosecutor. He's a federal prosecutor with me. So he was always never going to get caught up in the hysteria of the limelight of a case. He's going to rule on the law, and he's going to run a tough show. That's what this judge sounds like is what you need on a case like this. So hopefully they got the right judge. hopefully they had the right prosecutors and the right investigators working on it. And some of this evidence does not get thrown out.
Yeah. By the way, I'm looking at the side chat, completely out of left field. We are pondering. Tim, you don't have a generator up in Tallahassee, do you?
I do.
Oh, you do.
I do.
Is it for the whole house? If I may
No,
ask?
it's a portable one.
It's a portable. How does that work? Is it? How does that portable work? Is that
In my
outside?
it's in my basement. It runs on gas.
Oh,
And I can hook up about 13 lines. I can run a refrigerator, lights. My shower is gas, and my grill is gas. So we won't have heat and air. But you could run a fan, like in the summertime. You can run fans. I got refrigerators that work, and I can cook. So
interesting. I don't want to bore people with generator talk, but here in Florida we have hurricanes, and to get an actual like generator that like has its own propane tank dug into the ground, it's crazy. They want like $20,000 to $30,000. Tim Jansen, I'm not paying that.
Well, we got a bid on ours to do a natural gas, because we have a natural gas line.
Yeah.
And the generator wasn't the most expensive. They were going to have to rewire the whole electricity. Electrician wanted like $17,000 to rewire everything to hook it up to a full generator, and we decided not to do that.
Vesper, this is definitely true. Although in Vesper, in fairness to me, I don't know how most things work. I'm not the most handy guy around. I'll admit that. But here's the other thing, Tim Jansen. Let's just keep talking about generators for a moment as we wait for the Kohberger hearing. So, Tim, there is natural gas that runs on my street, but we do not have it connected. So then I had to call TECO, which is a monopoly in Florida. Mm-hmm. They want $8,000 to connect the line. Is that normal?
Yes.
$8,000.
It's expensive for them to do that. Yeah.
Can I hire you to sue them?
You can't sue them. They're not going to do the work. Natural gas is wonderful.
Yeah.
Because if your electricity goes out, or if you don't have electricity, generating, we can cook and shower, and that's pretty important depending on the situation you're in.
I'm envying Cooler by the Lake. She has a standby whole house generator.
They're wonderful. They're wonderful.
Yeah, that's interesting.
Don't buy a generator during hurricane season.
Yeah, that's what I'm trying to do it now.
Do it now. You get a cheaper price. Generac.
Yeah, Generac. God, Mr. Generac lives in a big house. I can tell you that. He lives in as big a house as Mogen and Mogen. That guy has a monopoly on generators.
His house is called Mansions.
Yeah. I'm kind of enjoying the generator talk here. So Tim, this was the best part of the conversation. I called TECO, and they tell me
that's Tampa Electric Company.
Yeah, they do all the natural gas in the whole state, I guess. So they tell me, yeah, we can do it. We can do it for $8,000, but you are at the end of the natural gas line. I go, what's that mean? They said, well, if there's a house to your east using a generator, there's a chance that you won't get enough natural gas to power the generator. So I'm like, oh, good. Let me spend $30,000. Let me get a generator and then not have, I won't know if I'm going to get natural gas. Yeah. So, I mean, that's kind of crazy. Then I'll sue their ass, Tim.
Yeah, you could do that.
Yeah, but for right now, I won't. So listen, I'm checking out X now because sometimes some information gets out there, and since we're waiting for this, so the comment here from a guy named Bobby Capucci. Sorry to put you on the spot. Sounds like a Jersey name, by the way. If Bryan Kohberger, Tim, wants all this transparency all of a sudden, he should petition the court to lift the gag order. It's interesting. It's like they want their cake and they want to eat it too.
Well, listen, that's two different things. A gag order is different than what happening in court should be a public hearing. Gag order prohibits you from speaking outside of court about the case. Right?
Yeah. Mish here, providing entertainment for some. Oh, look at this. Now we're way off topic. Ned Smith, you can count on her for this. Tim, do you know anything about diminished value on a car? I mean,
Yeah,
isn't it diminished the minute it goes off the lot?
the minute it goes off the lot, you lose 25% of the value.
Ned Smith, are you selling your car? My daughter, who's 10, already wants me to get her a car. She's getting ready to drive at 10 years old.
Get her a used.
Look at this. Look at the COE making an astute observation. It seems like everyone has a generator in chat. This is why the only ones who lose power every week. I need a generator in the studio so my Wi-Fi doesn't go out every 5 minutes. Oh, sorry to hear that, Ned. It was in a wreck, $15,000 worth of damage. Can Tim help you sue? Are you okay? That should have been my first question.
Yeah.
Ned Smith, are you physically okay? Let us know. Mentally is a whole different story. Someone is now writing a song talking about my generator. The Who. Anyway, I have sort of come to the end of my talking points here. And Tim Jansen, this can go on again. Again, for those just joining, wow, her car's in the shop for 2 months. That's almost like Phil Waters waiting to get his yellow Ferrari painted, which has been going on for like a year. I don't know what they do with that paint job, but it's been a year. So for those who are just joining, Tim, are you suspicious? Here's a question about the defense suddenly wanting things unsealed. I mean, that's what I was getting at. They want things unsealed. First, they want them sealed. They want the gag order. It seems like they're cherry picking what they want the public to see and what they don't.
That's right. It seems like they feel like there's something they want out publicly that will help them, that maybe the state messed up, or something that's favorable that they want to get out to the media. But they also know there's bad stuff. So you can't have your cake and eat it too. It's curious to know something must have gone the way of the defense that they want to release, and because of the gag order, they can't release it.
By the way, Alex Reese just reminded me, this is nice. COE let y'all know we have a generator when he's in Jacksonville for Shanna's trial. I don't know if we have a trial date even set for that, but I believe there's some hearings going on that we can't take because we're taking this, but one is Corey Richins, and that's a trial that I would like to go to, and one is Shanna Gardner, and then Courtney Clenny is in court here in Miami tomorrow, but I think it's a very quick
the stabber,
but
wasn't she the stabber?
Yeah, she's the OnlyFans model who allegedly ninja style flung her knife from the ground and killed her boyfriend. Never operate a generator in a small room. This is my biggest fear in life. They run on gasoline. Tim, how are you careful not to carbon monoxide you and your family, God forbid?
My generator is outside, and I run the cables run inside.
Oh, I thought you said it was in the basement for some reason. Okay.
No, I keep it in the basement, and I move it to the back porch near my barbecue wall.
Vivian James telling me to go to the Corey Richins case. By the way, if you guys want a specific case or trial covered, we can't cover them all. Someone please... not someone. You guys can email us, survivingthesurvivor@gmail.com. Super Planner Girl, who's helping us out with so much. I'm just looking for it. She has been pitching. I'm just looking so I make sure I get it right. Nazaya in, I want to say, is it Detroit or Chicago? Which is a similar case. Nazaya, similar case to Maddie Soto. If you all are familiar with that and you're interested, please let me know. You guys are part of the family, all of you. So your word matters. Let us know. By the way, if you missed it, there's this horrible case with the Alexander brothers. 42 women have come forward to basically say they're Sean Combs-like in nature, R-ing and drugging at least 42 victims, and they are going to be headed, if they're not already, to MDC Brooklyn awaiting a federal trial. And we had a victim come forward last night on the show. It was really pretty heavy and hardcore, and it's an interesting story, interesting information that she gave us. So if you haven't seen that, check that out. Tim Jansen from Buttercup 203. Why is it taking the defense so long to prepare for trial?
Well, it's a murder trial, and you've got a lot of evidence coming in a lot of different avenues, and it's all this stuff that's going to combine together, tell the jury what happened. So you got a lot of evidence coming from a lot of different places, putting him at the scene, putting him on that his DNA on that sheath, putting his car in the neighborhood, some of his text messages, things he bought, the knife he bought. All that kind of information is relevant, and it all together will show a powerful case against Kohberger. And so they're trying to keep every piece of it out, right? They want every piece of evidence out. And in order to introduce evidence, it's got to be relevant, and it's got to be proven to be properly admitted with the right foundation. And so that's what happens. And it's a death penalty case, so they're going over they're going to object to everything, which is not unusual.
Yeah. And again, it's going to be just about 3 years to the day, I think, when there's a verdict, if it does go to trial. Tim, how long does a case like this last? I mean, they sever the regular trial from the so-called death penalty phase, I think. But how long do you think this whole trial, which begins in August, will go for before it finally gets into the hands of the jurors?
How long did OJ? Didn't OJ's take like a year?
9 months.
9 months. We get death penalty cases here that could take 3 weeks. How long the Markel Charlie's took? 3 weeks, maybe. This case, I'm thinking maybe 2 months. I would think
2 months. It's probably too long for me to stay for the entire thing, but I'm definitely going to go out there for probably openings, stay a few days, and then go back for.
It really depends on the judge, what the judge's schedule, and how the judge moves, right? So,
looking at the comments, how does it? Where is this? From Nicole Luongo, Tim, how does the DA decide who tries the case, first chair, second chair, in a case like this?
Well, the first chair will probably be the most seasoned, most experienced prosecutor he has. And the second chair could be either the second most, or could be not the second most experienced, because that second chair might be having to run the office while the first chair is trying this case. And the second chair is going to be an experienced lawyer who's going to assist the lead prosecutor.
Look at this from Linda B. Inspired. I did bring it up earlier. There's a rule that I'm not supposed to unless someone else. Everyone go get Joel's book. It's literally so good. Best book of 2024. Karma's my hero. So for those who are in the West, I'm going to be at the Tucson Festival of Books, which is, I think, it's the second biggest book festival in the country after the Los Angeles Book Festival. But that is March 14th to the 16th. If you're in the Tucson area, make sure that's where I met the COE, by the way, but make sure you come say hello to me. We are still looking at this mesmerizing headline that says, "This portion of the hearing is closed." This portion of the hearing is closed. This portion. Tim, do I have you in a trance yet?
No, I'm just responding to something.
Yeah, no worries. So here's the deal. This thing could literally be like this for part of the day. They could come live any minute. We've kind of gone through all the bullet points, for today. What is this? Does Tim have any idea, what is this, who the mysterious cowboys were that showed up to the house one night? Did cowboys show up to your house, Tim? I don't know what they're talking about.
Mysterious cowboys were that showed up to the house one night. Whose house? Kohberger's house? Or
sweet soul. That's very mysterious.
We need more information.
Buttercup, are you sure you would get a seat at BK? I am a member of I am now an independent journalist, Buttercup. I'm no Fox News or NBC News, so I will have to fight and claw my... I'm not going to get into the trial because I'm almost sure that that's going to be next to impossible, but they'll have an overflow room, and I like to be there because then I can speak to people. family members, all those sorts of things. Courtney Clenny, latest, I'll be honest, I'm not 100% sure. The parents are not in trouble from what I understand, but the prosecution now is, because the defense is basically arguing that they got information off the computers illegally. So something similar to what I mean, just in terms of suppression that we're seeing here. So I think that's where they're at. The parents were arrested, but those charges, as far as I know, I'm almost certain that they have been dropped at this point. Huge question, very important. Did the snow melt at Tim's house?
It did. It's melting now. It finally got above 32. This morning it was ice, really icy, but it was fun.
This, I assume, is Bill Thompson. He is the DA for Latah County. He does look like Santa Claus. Tim, do you think that the actual district attorney will be in that first chair?
You know, that's not always a good idea. Just like in Markell's case, Jack wasn't the first chair. The elected official is not always the best trial lawyer in the office. The official is the representative of the office, and he's supposed to hire the best people to try his cases and win. He sets the policy and prosecutions and leads the team. I don't know this man if he's the best trial lawyer. I know Willie Meggs here tried some cases. He wasn't very effective at all in some of the cases he tried. So they really should leave the prosecution in big cases to the best trial lawyers.
Tim, I got to ask you, do you use like a hair gel, or do you have to like dry it that way? How do you get the like the pompadour effect? Is it just completely natural?
It might be the snow and stuff. I don't know. Maybe the climate. I don't know.
Just amazing hair from Tim Jansen. Joel, is the trial going to be streamed? Yes, it is. It's going to be streamed directly from the court. I mean, that's what's happening here. The court is streaming this. There's no pool camera here. They're the ones doing it. So there you go. Look at this. La Mesa. The GoFundMe for Joel and COE's dream portable generator. Up now. It reminds me of the show. Remember, what was the guy's name? Monty Hall, Let's Make a Deal. One of those where behind curtain number 2, they'd have to pick. What show was that? They had to pick the curtain, Tim. And then like sometimes it'd be like 3 goats. And
Let's Make a Deal?
I think it was Let's Make
a Deal. Is that Monty Hall?
Monty Hall, I think.
And the first person that has a paperclip? Do you have a paperclip?
Yeah, do you have a paperclip in your COE, by the way, has no idea what we're talking about. Zero. Yeah. Either the Space Ghost. But yeah, there was a show, Monty Hall, Let's Make a Deal. And he'd go up to like women with these giant purses and he'd be like, do you have chapstick in your bag? And if they did, then, you know, they would get to go up and then like pick a curtain, and it would be either a car or like 3 goats. So there you go. But for me, I get up there and I would win a generator and I'd be ecstatic. 3 curtains, correct. Oh, Sweet Soul's explaining this. They showed up at the scene at King Road. These are the Cowboys, Tim. They went in. Oh, these are like the feds. I know what you're talking about. They hid their faces the best they could, and they refused to speak to anybody. Those, I think, are just federal agents that were there collecting information at the scene of the crime. Deb says, I have other strengths. I'm not sure what they are at all. COE just started, and I started watching a show called The Agency. I just happened to come across it on Prime. COE's totally into it. I'm pretty into it. Tonight is the new season of Night Agent. I'm going to watch that. And Tim, I have nothing else to say. So it's your call. What should we do here? Should we?
Well, why don't we can adjourn.
Yeah.
And then if we hear some rulings or something, I can come back this afternoon.
I'll text you when it comes back on. So we're going to keep this screen up. You can read this over. I'm not ending the stream. Court will resume shortly. You can continue to read that. It's kind of like counting sheep until court starts. Yeah, let's make a deal. Ned Smith's got me here. They want us a video of Tim making a snow angel.
Too late for that.
We watched the first season of Linus. COE wanted to binge it in one night. COE's got this friend who will remain anonymous, who I just like totally pegged for a rom-com kind of person. Like I just couldn't imagine her watching anything other than something with Jennifer Aniston in it. And then she tells the COE about Lioness, and Lioness is insane. And I was like, wow, I never thought that she would watch Lioness. And it turns out that she's always watching crazy stuff. So now I am taking her advice. Space Coast has no idea. Space Coast, please, on the YouTube, check out Let's Make a Deal Monty Hall. It was a great show, man. That's when TV shows and game shows were game shows, not the crap that we have today. I like talking like my dad. That was my dad. This has turned into Seinfeld, the show about nothing, but yet incredibly successful. I often wonder to myself, I ask myself the following question: why would anybody watch me or this show? I mean, sometimes we have interesting guests and stories, but why you watch, I have no idea. I appreciate that you do.
What's Lee's question here? Please answer my question before Tim.
Lee, put it at the bottom of the chat, and I'll find it. What was it? Second, look at this, COE. Second season of Lioness is so much better. I never even heard of that show till the romantic comedy friend of the COE told us about it. I'm into what's the dude who's in Night Agent. That guy's in every. Wow, look at this. The court is on a break. That means likely that they've concluded. Maybe I'm completely wrong. Tim, what do you think? Do you think they maybe concluded the closed door stuff and now they're taking a break and will come back on camera?
I doubt that. They may have concluded a morning break for the judge or
One
witness.
thing, one thing about courtrooms and judges and lawyers, they're very big on their breaks. Tim, did you see the DA closing this week in Tennessee versus Chen? I don't even know what this is. I haven't followed this. I'd be so interested to hear your thoughts. Tim, do you have any thoughts on this?
I do not know anything about Tennessee versus Chen.
I know nothing either.
Give me some information. Maybe I can give you some answers, but sorry. I've been sliding down the hill with my dogs.
There you go.
You see that yesterday, Joel?
On Insta?
Yeah.
I saw Windsor. Yeah, I saw him.
He didn't like the snow as much as I thought he was going to.
Really? He's not used to it.
About it. Yeah.
Tentative?
Yeah, he was like putting his feet down, kind of nervous, and they got better. But he was like, I thought he was going to roll around in it like they do, but he didn't.
He's a Florida dog.
Yeah.
Was it 1970s? Let's Make a Deal. I think it was definitely the 70s. Let's Make a Deal may have run into the early 80s, but Vivian, I'm glad you brought this up. Joel, you mentioned a while back doing interrogation videos. We did one, and we did Phil FIL and interviewed someone in a kind of a very highly publicized case and got the guy to fold and confess. Phil Waters has, I think, the highest clearance rate of probably any detective in the country and the highest criminal confession rate.
Someone said Windsor too bougie for snow.
Yeah, that's Mish. We did it with Jen Soto. We did it. We're going to do more, and I appreciate that, Vivian. As a matter of fact, I just asked Scott to do one of his, but the feds are very protective, so I don't know that I can, but we'll get on it. And by the way, Vivian, since you brought this up, please, if you guys have ideas of police, like I wanted to do the JonBenet Ramsey police interview, but it's nowhere to be found. It's like scrubbed from the internet, from the webs. So if you guys have police interviews that you want Phil and Scott to kind of break down, please send them to me. survivingthesurvivor@gmail.com. This is true. Ned Smith, I'm amazed that you know this. This was my nickname for Mabel Rose, who is my beloved Puggle. Mabel Apple Allen Rose Johnson Smith III Waldman. All my friends know that. And I have no idea why that was her nickname. That was her nickname, but I have since named, we have 2 dogs now. Ethel, who is now named Ethel Bug Johnson as an homage to the COE and also to this nickname right here. And then downtown Freddie Brown, Frederick Morris Roosevelt Brown. The Morris Roosevelt is for Mabel Rose. And there you go. But yeah, if you guys have ideas or thoughts on, wow, I cannot believe there's 1,300 people on here, let alone 3 people. Yeah, right now there's 1,300 people, let alone 3, and I'm talking about my dog's nickname. Anyway, this is why podcasting is amazing. This is why the new world's amazing. By the way, did I tell you CNN just laid off 6% of their workforce today? I'm not happy for the people losing their jobs, but I'm not happy that CNN's falling apart and NBC doing the same thing. Traditional media is on its way to being put in a coffin.
Hey, Joe, one of your subscribers didn't know that I have an Instagram, Courtroom Chef.
Courtroom Chef, man. If you're not following Tim on Courtroom Chef, you're missing out. Yeah, Tim thought it was 3 people. Marilyn's like, Tim, 1,300 people. I thought it was 3 people. Courtroom Chef on Instagram. While you're following him, follow me, Surviving the Survivor. And Fred and Ethel have their own Instagram at Fred Ethel STS. So I can't really listen to myself anymore. So what we're going to do is I'm going to bounce Tim and I, CNN, why they were first 24. Yes, they were, but they're things change. And things are changing for CNN. I'm not happy that people are losing their jobs. Don't get me wrong.
No. Most of those people in New York, aren't they moving everything to Atlanta?
They're moving a lot of people to Atlanta. A lot of reporters are going to get let go. And a guy like Wolf Blitzer, who's been there for 130 years, is getting moved to
they demoted him
to the super early mornings. Jim Acosta, who's kind of
12 midnight to 2 a.m.
Yeah.
Graveyard shift.
Yeah. So glad about this. Yeah, Fred has been lifting his leg for some time now. It's not just CNN, it's NBC, it's all the networks, to be honest, every single one. Look at this. Thule Pool is back. I forget how to properly pronounce it, but Lesotho, I think it is. STS Best Guess. This is it's 7:32 p.m. in Lesotho, Africa, Tim.
Wow.
Amazing.
Come
visit Lesotho and host. I would love to. Thule Pool. I don't even know where Lesotho is.
Where is that? We need to figure that out.
Thule, you got to email me, survivingthesurvivor@gmail.com. I want to come. I'm going to do a live show with Tim from Lesotho, Africa, before it's all said and done. Did you see Lori Vallow?
We have a friend in Australia. She's going to be our tour guide.
I mean, Tim, we got to go on a global tour. When are we going to do this? Do you think that Morgan & Morgan would let us borrow his private jet if we promote him and go on the world tour?
I'll call John and ask him.
Yeah, please do.
He may be running for governor. So.
Oh, even better. Did you see Lori Vallow made a motion to dismiss her charges for conspiring to kill? I did not see that. That was probably, what is she not doing? These people just have so much. Jim Acosta is an excellent. I'm not laughing at him. I'm just saying that the entire cable news. I know Jim Acosta. He's actually a good guy, and he is a good reporter. But
he works hard.
Yeah. What's happened with cable news is that they've all taken sides, and they lost the idea that they're actually news people and are supposed to be objective. So I'm not laughing that anyone has lost their jobs. I'm just saying that traditional media is completely collapsed and is collapsing because of the changing landscape is what I'm saying. Michelle Cavernos here, Lesotho. Mish, where is it?
That sounds familiar.
Tim, they want your opinion on Lori Vallow trying to drop charges that she attempted.
The motion. If I get the motion, I'll be glad to look at it, and maybe we can talk about it another time.
Yeah, we can do that. This is what I'm getting at. What Best Nancy? There is no news reporting. It is all commentary. And you know what? They thought they were originally doing that for the ratings, and then that whole tactic just imploded on them. But there you go. That's what I'm getting at. It's not a personal attack against Jim McCarthy.
Why do you think they did it now? Are they losing ratings, subscriber?
Their ratings are at an all-time low. Same with MSNBC. I mean, they're just, and now that the election is over, and now they're, like it was, it's, I'm not going to say it. The COE is going to yell at me, but I'll say this. CNN and MSNBC mentioned the president's name more than any of the other networks. And people, I think, just got tired of all the, people just got tired of not having any objective news. Just getting people's political takes. And now it's backfired on them. It's as simple as that.
Hey, did I show you what I got for my birthday?
No, what do you get?
Let me show you. Hold on.
Yeah, by the way, Justin Lum local reporting is great. I have a friend who just lost his job because he's a weatherman, and now they want to do all the weather in Atlanta for stations on the West Coast to save money. That tells you the state of the business. What is that?
So this is Winston Churchill.
Yeah,
right?
it looks like Winston Churchill.
And there's a famous guy named Penley, famous artist in Atlanta, brilliant artist, and it's Never Give In, and he signed it, Tim Never Give In. And he's one of my favorite characters. I've been wanting this for years, and my kids got it for me, and they surprised me. And my oldest, who lives in Atlanta, she goes, yeah. They said, why don't you get it signed by him? She goes, I didn't know I could do that. And so they go, well, come to the shop. He'll sign it to Tim. So they come to the shop, and he's not there. They go, oh, well, he's playing basketball. Why don't you go to his house? So they gave my daughter his address, and her and her boyfriend went to the house carrying this painting, knock on the door, and they go out back, and he's playing horse with a friend of his, and he signs it to Tim, Never Give In. So it's going to be in my office. It's something really special, and I'm so thankful to my family and to Penley.
That's a very incredible, cool thing. Look at this. Julie Recor, I don't know. What does Phil, what does Tim think about Ashley Benefield? So there's a hearing today, Tim. She was sentenced to 20 years on a manslaughter charge for killing her husband, which she claimed was self-defense. She got manslaughter. She's appealing it, and she wants bail. She wants to be at home pending the appeal process. Have you ever heard anything like that? Is that common?
You can get appeal, but the judge has to almost admit that there was error, and that error, you're probably going to get a new trial. It's a pretty high standard to get that. Rarely is it given, but it could happen. I had it happen in one of my federal cases, and I represented a professor over at FSU, federal court. Judge granted bond, and I said, Judge, this is going to be overturned. He says, I agree, it's an issue. And the appellate court overturned it, acquitted my client. So it does happen, but it's usually one of those areas of the law. It's a nuance, and it's a close call, right? What the interpretation is. So I don't know enough about that case, but if you got 20 years in prison, getting out on bond, that's pretty hard that's not easy to get.
No, and apparently she's breaking down crying during that hearing. So we've got a lot to catch up on. We're going to, obviously, this is the hearing. Court right now is on a break. New programming. Yes, the COE is at the reins of this, but a bunch of best guests, including hopefully Tim Jansen. They're coming to our second channel, which is going to be Best Talk in True Crime, otherwise known as STS Talk. I had the idea because we've got a lot of amazing best guests with a lot of niche interests within true crime, and a bunch of them, like Tim said, hey, I'm a full-time lawyer, but I'd love to do something. I said, why don't you come on our second channel? And so that is what's going to happen. And people they're not going to be live shows. Maybe some will be, but there'll be shows that you can watch on the second channel that will be comprised of a lot of our best guests. We're going to start small and build it up. And then we are going to, I don't know, we're going to have fun with it. Jason Truth, he says the DNA was planted. Joel, please ask Jay Embray to go on your show. He's getting most views of any YouTuber. Well, screw him then. On the Idaho 4 case. I never even heard of this guy. He shows informants and drug connection without doubt. Jason Truth. I'll check it out. I mean, what can I tell you? I'm going to check it out, Jason Truth. It'll depress me because he's probably got 75 million subscribers right behind Mr. Beast. How does Mr. Beast have 333 million subscribers?
Listen,
330.
Joel, we're going to cover the Idaho case.
Yeah, we're going to cover it.
You know, I got another big this other project I can't discuss right now, but that doesn't work out. We're going to go do the Idaho thing, and it's going to be great. So hopefully I'll know something about this other project I'm working on soon.
Yeah, and I might do, well, you're going to do your thing, but I might go with you if that thing pans out. But look at this, K9 Catherine, SGS all day. It will be on the second channel. It will be a majority of the day once we get people up to speed. Who wants Tim Jansen to have a show?
Yeah, let's see. Is there anybody? Probably not.
I think everyone's going to say yes. Mr. Beast is pure brain rot per Space Coast. Yeah, I don't know.
Maybe if I cook on the show.
The Lioness
show cooking here in town. They want me to cook and talk stuff.
It'd be cool if you cooked and talked true crime while you're doing it. That'd be amazing.
I thought about that, but it's not that. Well, I might do that.
Yeah. Look already. The Tim Show. Everyone wants. Yes, I do.
Food, talk about the law and eat good food. That sounds good.
Yeah, talk about the law. Let's come up with a title right now. Burgers and something. Trials and Tabasco. Tim Trials, Tabasco, and Tasting. I don't know. We'll come up with a title. I'm all about the Tim Jansen show. Yes.
About grouper and guilty verdicts.
Jason Truth, he's known as Pavarotti. This guy's the best YouTuber on Idaho 4, and he sings like Pavarotti. Is that what you're telling me? D wants a decorating show from Tim's wife. Look at this.
Sure. My wife is so talented. She should have a show.
Yeah, Tim, we can pitch you to the Food Network. These are all great ideas.
Go to Courtroom Chef if you like and look at my cooking. Instagram, Courtroom Chef. That was a Freudian slip, but you can also go to Surviving the Survivor. Kitchen Justice. I like that.
Tim's Tasty Treats, Biscuits and Law.
These are good.
Cooking with Crime Time. Look at that.
Wow, these people, that's great.
That's a good Ned Smith. I'm impressed. Crime and Cuisine. Slay That Filet with I'm laughing at that because my 10 and 9-year-old daughter now, all they do, I'll be like,
wow, these are great.
I go up to my 10-year-old and I'm like, hey, I got us a ticket to go see the Miami Heat, and her response is slay. I'm like,
I love Kitchen Justice. That's good.
My son called me, and my middle daughter called me bro the other day. I was like, if you ever call me bro again, bro. God, these kids today, Tim. Do you ever get to a point where you feel like your father? Like, I'm like, what does it matter with these kids? They call their dad bro. Who calls their dad bro? I would never have done that. There was a time, and I was listening on the radio. There was a time when people were afraid when their dads would get home from work. That there was a time like that. Now dads, they got to go to every single birthday party, every single thing, every event. I mean, I understand that I'm their father, but I tell my kids, I'm not your babysitter. I'm your father. But then there was a time like when your dad would come home, you'd be like, Bill Burr does a whole thing on this. Like he would run for safety. His dad was like a grumpy dentist, come home yelling about stuff. I don't know.
I've been
anyway.
My kids have not called me bro.
Yeah, well, your children are respectful. Um, if COE, if my kid calls me bro again, it's going to be major problems. Problem is, the COE teaches the kids half this stuff, and and Carm teaches them all the curse words.
90.
Poll results.
Who
Yeah,
was
look
the
at
other four? Who was the other 4%?
this.
Sorry.
Uh,
What can I
and
do to
new
earn that 4% back?
Bill Burr, by the way, best stand-up comic in America. Period. No one close right now. He is hilarious. Um, Absolutely hilarious. Tim passed with almost unanimous approval. Um, they don't fear me, Joel. You can say that again. My kids don't fear me. I got invited to a Heat game the other night. I got my kids a Heat T-shirt. It's like me handing them a napkin or something. They were like, "Oh, thanks." I didn't even say thank you. I was like, "Do you guys say thank?" I'm gonna move these kids the hell out of Miami. Teach them some respect. Understand that not everything is Ferraris, Lamborghinis, and Botox. These kids have it all wrong. Anyway, oh, thanks. All right. Anyway, Tim, I can't do it anymore. We'll
Yeah.
come back on.
Hey,
I'm
listen,
gonna
I'm going to be home, so I can come back.
Hmm.
My birthday was the 28th of December.
Happy birthday, Tim.
Thank
Look at
you.
this. Tim Jantz merch ideas. The case is cooked. Kitchen aprons and
Man, I
oven
love
mitts.
these people. These people are really smart.
True
I'm
crime,
proud.
true crime chef. We're
Wow,
gonna do it. Um,
this is great.
yeah,
Yeah, I'll cook while I do the show. Right?
that's a
I'll make
great
a dish.
idea.
We'll talk about cases. Yeah.
Yeah, it's a great idea. All right, everybody. So this is the stream. It is live. For those who are just joining, there is a Kohberger stream. Part of it, this part is behind closed doors. We've recapped as much as we could do. We talked generators. We talked Tim's cooking show. A lot covered on STS all the time. And there you go. Tim, thanks. I'll text you when they come back, and Tim will
Yeah,
come back at
I'll
some
be
point.
available.
And I'll be here once court is back in actual viewing session. Until then, thank you. I can't end the stream. Thanks,
Okay.
Tim. I'll hit you up in a bit, and I'm bouncing myself out. See you guys in a little bit.
Are we ready to go live? All right, go ahead. Let me know when we're ready, Sandra. Ready? All right. We are back on the record in State v. Kohberger, CR 0124316665. We are now, I believe, streaming for the record. The defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. We are now going to hear argument from the parties on the Frank's motions filed by the defense. That will include the Frank's hearing that was held on the IGG issue, as well as the defense's proffer as to the rest of the Frank's issues as to why the court should hold a hearing on those matters. We'll hold an evidentiary hearing on those matters. Am I missing something we talked about?
Your Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
Well, the suppression IGG, we can also argue that. I think it's wrapped up in the same issue. I thought we were going to Frank's next.
I did not. I apologize.
No preference over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Frank's items ready.
Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. If that's what you're prepared to argue.
Thank you.
Go ahead.
Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required. None was given. And so this must be suppressed. Your Honor, I'd like to identify the 3 stages, and they are when Idaho State Police Forensics Lab through Moscow Police Department moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All 3 of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed. Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the jed.com file. I don't have.
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Bryan Kohberger's DNA was on the knife sheath.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA.
Right.
Those databases don't churn out a name and say this is your suspect.
I have a privacy interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA. But
not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position.
I agree that part is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
Well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How was it in violation of his rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here, he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law. And I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that abandonment is a knowing intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different search.
So I'm going now to, I'm sorry, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea, that somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about. Okay. Our first point is it was an illegal search. And this is if
the search,
the
which search?
Assumption.
Which search? It was illegal.
Well, first the snip at Othram, then the snip at the FBI, and then the trash pool.
So you're talking about the DNA testing of the material left allegedly on the knife sheath.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS, uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret, that happen when there's a portion of the DNA taken and it's searched by Othram to create a snip. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the snip ourselves. That's what I'm talking about. Those are the problems. As far as asserting family.
Specific DNA tests done of the sample that goes from legitimate to illegitimate?
Yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath.
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose. And I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is
Give me the
Carpenter.
cite to that.
I'm sorry?
Can you give me the cite to the Davis case?
I can. Give me 2 seconds. 2 seconds and glasses.
And I apologize because my memory tends to be fact-based and not name-based. And so that's my liability.
Well, it's going to take me just a second. I apologize. I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. Can't remember what page. It is 690 F 3rd 226.
Okay. Go ahead.
All right. And so those are the 3 areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I'd talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Don't suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IGG databases that changed their rules in terms of use after a different case used IGG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
Got to be a standing.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law. That's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case. There's an expectation of privacy.
I struggle with, well, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here. And that case was about, it was about third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you
Fingerprints
went.
everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you go, you drive your car to go to the doctor, your cell phone's hitting on those towers. DNA is even more personal than that. The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches. And that's what we're asserting here. I mean, there's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left if that's going to be the standard. You put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And instructive, I think, and important for the court to think about this all was. We are months from trial, and we are about how the government identified Bryan today. In open, we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Thank you, Your Honor.
Why should I permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search?
So a couple points on that. First, even assuming that that's all correct and that they violated the terms,
Seems to be the evidence.
the terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
so I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that is reasonable expectation of privacy against law enforcement. It's against the public writ large. So for example, we cited in our brief 3 different cases where Idaho courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain. And certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document. And if you look at the policy in footnote 1, it clearly says this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques of justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. In other words, their first problem is they're relying on a policy at all. The U.S. Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these things.
Well, if you were interpreting this as a matter of contract, wouldn't you have a problem in the sense that on the one hand, it says don't this, and on the other hand, you've got a more general sort of catch-all that says, but we're not really meaning anything we say.
No, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law. And it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. But despite all of that, the U.S. Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide at a crime scene. There is no case law anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the plain view doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found. And they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those snips, he said, quote, "A lot of research." So the defense is positing this question of, they're saying the court needs to ask itself, what could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the US Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA can reveal a bunch of private medical information, and the US Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not in fact tested for that end." So the question under the Fourth Amendment is not what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to medical information about Mr. Kohberger. It was all related to ancestry and identity. And as the US Supreme Court said in King, there is no greater privacy interest in DNA than in fingerprints, so long as law enforcement is limiting its activities to identification. And that's what we have in this case, is identification. Now, the other problem that Mr. Kohberger has here is, in my view, at least, he's been a little bit wishy-washy on the DNA on the knife sheath itself. You don't get to claim Fourth Amendment standing and then just say, well, I have no idea how it got there. Again, the Idaho Court of Appeals has held in a couple different cases that if someone, for example, in one of the cases, denied the existence of a bag that had been thrown out of the window, and the court said, well, you can't have a reasonable expectation of privacy in a bag that you deny exists. This is a very similar thing. We have a defendant who is trying to get the best of both worlds. He's trying to say, well, it's not my DNA and the state can't prove that, but he's also trying to say that he has Fourth Amendment standing. And that is not how the Fourth Amendment works. Your Honor, I also wanted to respond to an argument that was made in the reply brief, since I didn't get a chance to do it in the briefing. And this has to do with the trash pull in Pennsylvania. And I'll just start by saying that the defense has offered no evidence whatsoever that would take the trash pull in this case outside of the Idaho Supreme Court's decisions in Donato and Paluzzi. Paluzzi is very recent, came out in the middle of the briefing, in fact, and rejected the exact arguments that are being pressed by the defense here. Obviously, this court is bound by that reasoning. When the state pointed that out in their response brief, in the reply, the defense made an assertion that this case is different because the documents the state has provided are not clear on where the garbage cans were located, and that maybe the officers went up onto the driveway instead of collecting them from the street.
Trash company collected it.
Correct. I'm sorry, Your Honor, I misspoke. The trash company collected them on behalf of the officers.
They just did the regular pickup, I thought. And
Correct.
Pulled over after they got out of the neighborhood and said, here's what we grabbed.
Well, I do believe it was prearranged with the FBI for them to do that. But my point is just, I do think it's telling that they didn't provide the court with these documents that they believe are not clear. And I looked them up to make sure that they were. And in fact, there is an FBI report that was disclosed in discovery that details that the garbage cans were at the end of the driveway, at the end of the property. And at the end, it says, see video. And there was a video disclosed in discovery where you can see the officer's body cam as he drives by the house shortly before they look in the garbage cans. And they're in the exact place you would expect garbage cans to be when they're out for collection. So they, of course, have the burden of establishing a search. They haven't presented any evidence to that. It's not sufficient for them to stand up here and say, well, it's just not clear. Which brings me to my final point, and that is Ms. Taylor continues to say there was a lot of secretive stuff happening in this case. That is not sufficient to satisfy their burden that there was a search, that someone had a reasonable expectation of privacy. When you have the burden, you have to present evidence. You don't get to just stand up and say, well, it was very secretive. I will note in this case, as the court may be familiar with it, as it's probably read back through the record, the defense in this case has gotten a lot more information than many defendants in other states who have, where there's been an IGG investigation, because the majority of courts have found this isn't really relevant information. It's just a tip. Now, it is what it is in this case, and we, of course, complied with all the court's orders and provided the information, but this isn't, there's not a lot of information, not because it's secretive, but because it's just not our case. It's not what we're focused on. It's not the evidence we plan on using at trial. And yes, IGG was used in this case. And yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, we'd ask you to deny the motion to suppress.
If the FBI, in fact, violated the Fourth Amendment rights of Mr. Kohberger, you would agree the state is burdened by that?
That's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
I'll start backwards. I will answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept. They didn't want anybody to know what. It is interesting to hear that discovery requests and motions to compel and orders have been complied with when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing so far today. That's a surprise to me. So I wanted to say that, and I want to go back to the trash pool. And I want you to know, when you consider this, that that particular area had an ordinance. Trash had.
The court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the ordinance, that it has to be collected by a trash collector, that a certain trash collector, and that you have to put your trash out too. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case. How does
that change the analysis?
Well, Your Honor, I think that it changes
the expectation of privacy is lost when you put it in the trash can to be taken away per the Supreme Court's opinion, even if it's a well-regulated neighborhood by ordinance that says when and where you have to put your trash.
Well, Your Honor, I think expectation of privacy, when you have to comply, you have to put your trash out in that particular manner.
Not the case.
Unless
you're saying this Supreme Court was wrong.
Everything.
But I have to follow what they say.
But I have to make a record when I don't agree.
I appreciate that. I'm just trying to make sure we're talking about the same thing.
And I have to distinguish the case as best I can as well. And I think it is different when you have the FBI telling the trash man what to do. I'll move on to something else. I want to talk about now where Mr. Nice started that Department of Justice interim policy, and he read you the first footnote. And I would just direct the court to pages 6 and 7 in that. And that is that the FBI is not to search databases that they're not allowed to. In this case, the 2 of the 4 that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. The prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant. And it's thought of in this Department of Justice policy as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip. It takes it out of being a lead in the case. I would remind the court, I'm sure the court knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did to develop this profile with the rest of the secret things that they did in this case, and their willingness to violate their own policy. Certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice policy, but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider, just like you would in any other confidential informant type of case. I would like to distinguish what we have here with our subsequent search. I talked a lot about that before. I won't go too far on that. This is a second search and a third search if we're just focusing on the 2 SNP files. These are extra searches that happen after the initial search is done and the STR profile is developed and it goes into the CODIS database. This is completely different and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology and the standards that apply are catching up and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine. It's not the same at all. There is a ton of information. It's your whole genome that gets profiled. Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality of that. People have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go to the doctor if we want anything released to our surgeon. Health matters are important. If you can upload one of these profiles for $12 and find out all kinds of information, how is that not a Fourth Amendment issue? That's what that SNP profile can do. And that was done twice without a warrant in this case. And there should have been a warrant. It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
Thank you. All right, the matter will be taken under advisement. Let's proceed with the Frank's argument on the IGG and the Frank's proffer more generally. Or did I get it wrong again?
Your Honor, I'm prepared to do that. I would request that the court maybe give me 5 minutes. I have
All right.
different things.
We'll take 5.
Thank you.
Back in 5.
Man, the Zoom operator is quick on the trigger there. Immediately going to the court is in a break, but basically they're just arguing, and I am no attorney here, but sometimes occasionally play one on YouTube. So the obvious issue at hand is the DNA that they're going back and forth about IGG and about how it was collected and whether or not it is constitutionally acceptable. The defense and Taylor is going to do everything in her power potentially to get that suppressed, because that would be a massive win and would limit the amount of evidence that would come in at trial. She basically started the hearing arguing something that the judge was not expecting, and then got into the whole trash issue. Trash searches, the judge alleged right away that they're fair game, essentially. He actually asked which search was illegal, and she responded that the SNP DNA testing at Othram, the FBI, and the trash pull, those were all illegal. There was a bit of new news today that I don't think I've ever heard before, and that is that the FBI actually arranged for a local trash company to come and collect the garbage from the street in front of the Kohberger's house in Albrightsville, PA. And I wonder if they still live there. That would be kind of crazy if they do. But so that's what came up in the arguments today. Ann Taylor arguing that the FBI violated some sort of interim policy by searching the DNA database. But this is how they've got other people. Again, the judge asking, how's this a constitutional violation? And then Judge Hippler basically said to the state, to the government, why should he allow the evidence in, kind of playing devil's advocate. And the prosecutors say, because there's essentially no expectation of privacy at all. And that's what leads to right now. So the next issue continues in this hearing about suppression of evidence. And Taylor obviously needs a moment or two to prepare. She asked for 5 minutes. I am prepping. Vesper Martini is telling me that is new about the FBI coordinating with a private trash company, which appears to be the case. Emma is saying that Kaylee's family is in there. It's interesting. I was focusing on Bryan. There's very few people in there, but I will take a look to see the Goncalveses when we are back in session. We should be coming back in just a couple of minutes. She asked for 5 minutes. We will find out if it's 5 minutes, 10 minutes, 15 minutes, but I'll be here through the duration of this hearing. This is going to almost definitely extend to tomorrow in the chat. I know this is not the way the COE does it. Would you like us? I've got Phil, FIL, and Phil Ramos from Vegas, PHIL, scheduled to come on 12:30. Do you guys want the COE to run this tomorrow on the second channel? Let me know. Thank you. Appreciate you being here. That's all for now, folks. By the way, if you haven't already, please subscribe to the second channel. It's going to be the best talk in true crime. We've got our best guests starting next week and the COE who are going to be hosting shows on that second channel, obviously all related to true crime. We've got all these guys with different specialties. The profiler, Doug McGregor, is one of the first ones coming out of the box. And then you've got Dr. Detective Troy Looney, and you've got Rob D'Amico, former FBI HRT, which is a hostage rescue team, a very elite unit. He's going to have a show. The COE, and the list is going to grow. Dr. G is going to be doing stuff with us. I believe even Gigi McKelvey at Pretty Lies and Alibis, or she's going to at least be on with the COE. So stay tuned to that. And you see the second channel link. You can sub to it right here.
All right, let's take up Frank's.
Your Honor, I think on the court's bench, there was a document placed, so
What?
it had initials to comply
thank you.
with the court's.
Appreciate it.
All right. Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Frank's hearing. To do that, we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger, and without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Frank's hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on. So
We did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
my only point being that's not in the preliminary stage that all the other issues are on.
Okay. Well, I'll try to hit that as hard as I can then. Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that for the first time ever, Bryan Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret. That's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Bryan Kohberger. He had not crossed their radar. That's nowhere in the affidavit, and that's important because that's intentionally withheld from the affidavit because of the work the FBI did. Because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Had the judge heard about that, signing probable cause, that would have been really important to understand We don't know this name. We heard it for the first time now, and we only know it because we violated our own policy to find that. That may have given the judge caution. It may have made the judge wonder what else are they doing behind the scenes. But that was withheld from the judge. That judge never got to know that. Let's talk about what the judge did get to know with that in mind, and that's a really important backdrop. These affidavits are a group effort. I think the court's heard a little bit about that. And if the court has some of the initial exhibits, the court will know, and I'm at D2. The court will know that this was a group effort. The FBI, the same FBI that went behind and violated their own policy to try to identify somebody. They were co-located with Moscow Police Department and working on these affidavits to present to the judge. The first warrant that gets anything related to Mr. Kohberger is, I refer to it as AT&T 1. It's on 12/23/22, and it's for 48 hours worth of records of Mr. Kohberger. And I want to go through that warrant with the court having in mind that the IGG was purposefully and intentionally withheld from the magistrate. And I want to talk about some of the other problems with that warrant. This probable cause affidavit talks about an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says, this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure. I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go down the stairs, go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. I've got one more of these where this is repeated. It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs. that that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real, or whether it was at a dream, and that is contained in defendant's 8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things, and the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion. Your Honor, the next part of the affidavit talks about what they have determined to be suspect vehicle number 1. And it trails a path of pieced together cameras. But what they don't tell the magistrate is that the camera near the residence, the 1112 King Road camera near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car, that their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. That's withheld from the magistrate. That's important information when you tell a magistrate, we found this car doing this thing and we know what it is. It's around this particular area. The next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them, and the court knows this and can read about this. This is going to be in D10. That's in D9. And finally, after several submissions, that's when the FBI IML says, I can make a car identification. The issue with that that's not disclosed to the magistrate is that car appears one time on one video and not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car where it appears again. It appears one time, and then what law enforcement did was they took several videos from all over the area and said, well, it's the same car and we have an identification. That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra. And that's what law enforcement relied on. The court has, it is D12, and it's the Be on the Lookout that was issued by Moscow Police Department, where they look for a 2011 to 13 Hyundai Elantra. And that's what they're looking for. And they don't tell the magistrate that's what they're looking for. They mislead the magistrate and let the magistrate believe that they have a clear view of this car making this loop. And that's just not what happened. It's pieced together and it doesn't make a whole lot of sense. Law enforcement in their affidavits talked about this dog barking, and they key some time. And they say, this is when something was happening inside this house. We can hear this dog barking. And they use the videotape to get a time off that, the surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail that they've picked out a time that something probably happened here. And they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. The magistrate is not informed about that either. Then the police department goes through maneuvers to tell the magistrate that they did this investigation. They talk about a traffic stop, 2 traffic stops actually, and there's no connector in there. This is where the lack of the IGG becomes really important. If you know about the IGG, you know why that would be built. Otherwise, 2 random traffic stops months ago in pretty populated areas with a lot of college kids really doesn't add up to be an investigation. But those are put in there to try to bolster up this investigation and say it was something that it wasn't. Probably the worst part of that is relying on, after the BOLO went out for 2011 to 13 Elantra, then WSU, Washington State University officers find cars. They find one that's registered to Bryan Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the detective, the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't. You know that's the case when you look at a couple of our exhibits. One is prior testimony from that same detective. And if you look at the messaging between the detective and the WSU police officer about the timing of that. So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge. If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
If I find that the IGG was not unconstitutionally obtained, doesn't it just add to the probable cause?
No.
If it were to have been disclosed, it would have simply created more basis to suspect Kohberger.
Your Honor, if it had been disclosed, think about how that would read. We used a process to make an identification. This is a new technology. This is called investigative genetic genealogy, and we identified somebody. We did not keep any of our documentation because even though Department of Justice policy says we need to, we decided not to. Even though it says we can't go into certain databases, we really wanted to figure out who this was, so we just ignored that policy altogether. I don't know how a judge could find that credible. You don't even know how that happened. There is a great big question mark about how that happened. To Your Honor's point, you should find it unconstitutional. If you don't find it unconstitutional, it's a separate analysis. I appreciated being able to talk to the witness about that today, but it's a completely separate analysis. You're looking at integrity. You're looking at what a court can rely on to sign off on an affidavit or a search warrant. If an affidavit is presented to a judge and you know that the rules don't matter, that terms of use of a database don't matter, and that you're going to hide what you do, and that doesn't matter either, there's not a lot to rely on. If law enforcement came to the magistrate and said, we want to go search this house over here, and they said, we really think there's going to be evidence of a crime in there because we've got this confidential informant, and this confidential informant has provided a lead, but we need to tell you that we don't have real reason to trust this confidential informant because they won't tell us how they know that. They gave us a picture, but they won't tell us where they got it from or when they got it or what means they used. They threw away their camera. They threw away all the metadata. They won't tell us anything about that. And by the way, the confidential informant maybe has some integrity issues. A judge is not going to sign off on that. And then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
The purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front. It wasn't to suggest it's otherwise connected to the homicide, except to say this is a car of interest and the defendant was found driving it.
Well, let's talk about that license plate for a second, though, because that's not something you can see from the videos. And that was testimony you heard today. You can't see that from the video that the cops relied on here. So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff. That wasn't known before. There was no video collected from WSU before. There was no communication with the officers at WSU before. So before the identification through IGG.
I'm just not tracking why that matters. Go ahead.
It matters because this wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that PC affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you. I do want to comment on the affidavits being used by a variety of officers. I understand the collective knowledge doctrine, but that's not what is going on here. You have an affidavit that sometimes Moscow police attribute it to the person that really wrote it, but quite often it's just the name taken off, and who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well. But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Bryan Kohberger's phone. They do acknowledge that his phone wasn't contained within the geofence when they looked at the geofence. But this second warrant is important, and we're going to talk about minutes difference of time. In the first AT&T warrant, in that affidavit, the police officer talks about 2:42 a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find a white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Kohberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard where one could turn to go to Moscow at 2:42 is inconsistent with 2:44, but they don't correct that. They don't correct that. They don't say that vehicle at 2:42 cannot have been the right white Elantra running around that night, because we now know it was at 2:44 a.m. They want to keep that in there because they want the car positioned like it's going to be going to Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m. And that's not right. We submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records, and that's just not right. Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about 2 towns that are fairly close together. And so the way a car points when they go off the network matters a whole lot in this circumstance. That's not corrected in any of the affidavits. That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that that phone wasn't traveling in, to create a false narrative for the magistrate to rely on to find probable cause. Your Honor, I draw the court's attention to D7 and 8. Those are the affidavits from the defense experts. Their CVs are in D28. Once the second AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records, but based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side. But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking, because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report, because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I mistake me thinking of a different date for the AT&T. I thought, not the cell tower stuff. Are you still talking about the cell tower stuff?
No, I mean, that stuff applies to every single warrant we have, because that was
I thought
early.
you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about,
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the
What
individuals.
is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
Not in this context. Not in this context, because of the IGG work. Because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question. You're
Killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car. Let's just go with.
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that might be the case. And when a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with a murder weapon. I have not yet a magistrate would not find that probable cause.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say. There's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, that they told the magistrate about, that this is the video, this is what matters. It parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked. There's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence when there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
Okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car and the court's question, good question. What does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Applying the Frank standard, which is even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts. As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable causes to Mr. Kohberger if his DNA is found on a knife sheath found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is, how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers. And all of a sudden this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Bryan's car, in Bryan's apartment, that there's no other DNA in there other than an unknown male B that we know of for sure, an unknown male D outside. There's a lot of context there. And all of a sudden, this one thing, the question of how is that there is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true. One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. You know, the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection. The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this when they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think necessarily, that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions. Yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
I was understanding completely.
Yeah, thank you for that. I wasn't following the question the court was asking. I think the other thing, I think I covered all on my proffer, Your Honor. Thank you. Sorry.
I think now, Mr. Nye, were you going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of it.
All right, go ahead.
I'm going to attempt to. Good afternoon, Your Honor. As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's, that were attached to each of the affidavits for probable cause. That they were the basis, which were the basis for multiple search warrant applications. That within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence or Scrivener's errors or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim, and they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A. As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
what do I do if the affidavit is attached to Detective A's submission? Is it Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that
made it. It was another person on the team, let's say the cast member expert.
Well,
How does that affect the Frank's analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede, I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding cast. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm gonna talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same claim is in Exhibit A signed by Detective Blaker.
Thank you, Buttercup, for the super chat. We appreciate it. Thank you.
The officer signing the affidavit did not claim to do the cast work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, SA Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead is just a reflection. The work was done by Balance. Investigators reviewed that and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is cool.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed the Frank's motion.
What specifically?
That there are 3 towers.
I believe
Remember,
I referenced
we're
it in my
proper-
response.
Well, yeah, but that doesn't, if you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I'm been very clear to say I'm looking at what the proffer is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's what is in evidence though. And based off of the PC affidavit is that the phone was in the area for the tower that provides service to the 1122 residents. Still maintain that's true. Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding an eyewitness statements related to DM. There's kind of 2 buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant. Well, it's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
I cited those in my response throughout.
What were they?
Okay. I can tell you generally, consistently, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things? In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place?
Both.
Okay, so it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred. Yes, a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important. It was that general description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline to know when that the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period. And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit, you can take all of it out and the magistrate would still have probable cause. The second issue defendant, the second kind of bucket that they take issue with DM, is about these other just statements that she gives during her interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification. Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Bridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene, they say, well, that can't be the right video, because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
It was submitted through my response, that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter. At the end of the day, the defendant's speculation about the route of travel and their differing opinion on it isn't the basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion. And they haven't made a substantial or a sufficient proffer for you to do that. Next, the briefing addresses the IGG issue. And
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that well, I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No, nor did we need to. Really, the IGG has been discussed extensively. I think the only real Franks issue is, should the IGG process, the fact that it was not included in the PC, is that the basis for a Franks hearing? But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IGG and the use of IGG is only inculpatory. And the non-reliance on the IGG information does not diminish probable cause. And the IGG information was confirmed through the STR testing. I can't wrap my head around any argument that IGG and STR testing would be exculpatory. Defendant makes kind of hay about the dog barking. And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take all information related to the dog. It doesn't diminish probable cause. Circling back to the cell phones, at the end of the day, this is the proffer is their opinion of the evidence. That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Frank's hearing. Defendant next, the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendant's opinions about where the shoe print should have been located and it couldn't necessarily have been located there. Again, that just doesn't rise to the level to warrant a Frank's hearing. Again, our case doesn't hinge on the identification of this shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information. I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Yes, before you get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed position of travel?
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's-
Detective Payne? Or by the
With
cast member?
information that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay, No, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's
If
material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off, isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning, which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not. It's a leap for me. Does that answer?
Well, it's your answer, so.
Let's say it was. Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included. It wasn't, but let's say it was. Well, the magistrate still had enough information before her to grant probable cause for the arrest. So we still don't get to a Franks hearing, even if you want to make that leap. I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Franks hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Franks is not the proper avenue. We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft. However, even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause. I submit to you the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have found probable cause. I ask that you deny their motion for a Franks hearing. Thank you.
Well, briefly.
I'll try.
I'll try to do my part to make you so that you can and avoid asking questions unless I'm truly stumped.
Before I get started on what I want to tell you, I'm in response to what the state said and then my summary. I'm curious about the new police report that was talked about. I didn't see it in the submission given to Your Honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Franks hearing.
Well, that's good because it occurred after my Franks briefing came. So I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas. And yeah, we wanted those in discovery. We didn't get those. We were told no a couple of different times. The issue with that is that at least one of the warrants was used, the returns from the grand jury subpoenas, it used the return from the grand jury subpoena to obtain information. And we don't have those, so we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us. And that's kind of gotten to be
Amazon.
Sorry?
Is that Amazon?
It is Amazon, Your Honor. And the return on the search warrant says that they already produced them pursuant to something else. And the affidavit says, we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me. It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem. So I think we should have a Franks hearing to explore what that really is about, if for nothing.
What's the omission that, or the misstatement that you're, as it relates to the Amazon warrant?
The omission is the FBI used the grand jury system and obtained this information outside of the warrant process. But for some reason, we need to come and get a warrant because nobody gets to. I have them in other cases, Judge. I don't know why they're withheld here. It makes me really suspicious.
Well, I mean, I guess from a Franks perspective, though, the question is there a material intentional misstatement or a reckless misstatement?
From Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
It's disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the parameter around that grand jury subpoena.
How is that? Well, I understand. I promised I wouldn't slow you down, so I'm going to let you just go ahead.
Okay. I'll go backwards. The 7 minutes that's not disclosed, that's intentional, that's not given to the magistrate to make the decision. there are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate on all of those areas. I want to talk only about a couple of other things. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it 4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it, like half this stuff. I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle's identified on the camera near the house, and that's not so. It's not identifiable. The state's expert said it's not identifiable from that particular video. It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridge Road footage to identify the vehicle?
What did they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
They relied on the Ridge Road camera, and you can see that in the emails from IMO and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make a positive ID on the car.
Where is that in the record?
The 1125 Ridge Road. Well, it's in our discovery.
Or is it in the motion?
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you. Is it in the box? It's in one of these. Your Honor, I believe it's on page 17 of the amended memorandum.
That's just the photograph,
Yes.
but not the information that ties that to the Ridge Road camera.
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that. I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court, that was the video that the identification was made on. That, I'd love to know more about that as well, Your Honor.
Oh, but that's not the standard.
I understand that. I understand that. I would refer the court to our exhibit with Agent Immel's communication. I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today. I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there, but nothing happened until the IGG happened behind the scenes and in a closet. That brings me to talk about the intentionalness of this in an overview. And the court should look at the entire picture of what's happened. It's a long investigation. It's a complicated investigation, but you have law enforcement repeatedly meeting, and you have FBI agents sprinkled in. And there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk about. And there's a lot of meetings that are happening, particularly around the IGG. That's a definite, we're not going to put that in there. But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off, or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that. There's review of the videos together. And what these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant. That was, the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made to leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did, so that we could check their work and see if they did anything right. That just continued with decisions to leave things out in this case. Probable cause doesn't get determined by one little thing without context, especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question. There's a lot of power in that to obtain a warrant. And there's a lot of danger when there's that much power too, to leave just a little out here, to add a little more here, and go get a warrant and then build everything that comes from that. And that's what's happened here. Your Honor, we ask for a Franks hearing to more fully explore these. The court can see this is a massive amount of information. The court has 1,000 pages. These aren't just pages that we made up. There's a lot going on here, and we need to have a hearing to fully explore this. Thank you.
Adjourn for today. Frank's motion related to the Frank's proffer under advisement. Issue opinions on those forthwith. We will pick up tomorrow with trying to think. We're probably at the evidence on the motions to suppress tomorrow, correct?
Yes, Your Honor.
All right, I'll see you in the morning.
There you have it. 8 hours, 1 minute, 29 seconds. Only part of that was on camera. And you heard the Judge Hippler, say at the very end, by the way, Ann Taylor is pushing for a Frank's hearing, which is a suppression of evidence hearing. But this continues tomorrow. It will be on the second channel tomorrow. The COE will create a YouTube link for you all that will take you right there. When you're there, please, if you can, subscribe to the second channel, because starting next week, we are starting the new channel, and it's going to be Best Talk in True Crime. I got the idea from sports talk radio, political talk radio, even though there's no politics, but people talk about all aspects of sports and politics. Well, why not true crime? It doesn't exist, and we've got the best guests in the business, and they want their own shows. So we will do that. I don't know what the COE is saying. It sounds like it's going to air, although I'm not sure. But COE, gonna need a thumbnail. I set up tomorrow's show with Phil and Phil, and COE, you got to get that thing back to Tarek immediately, please. Taking care of business on the air. We'll talk. The COE says that always scares me. Courtney wants her own show. Let's get it done. But yeah, Tim Jansen will do a cooking show. I am going to bounce. The good news is I prepared all of tomorrow's stuff today. So thanks to Bryan Kohberger and Ann Taylor for that. I appreciate it. We will see you tomorrow. What was this comment? I just saw a comment that I wanted to read, and then I clicked off. Just subscribe to everyone. Julie Frew is amazing. Amanda, Super Planner Girl. All the mods are amazing. I can't. Seldom are Frank's hearings granted. This is true. Okay, and Jay, thank you for, or is it Joy? It's Joy, not Jay. My eyesight is going. I don't have my glasses on. All right, everybody. Love you. Love you, America. Love you, Idaho. Thank you to Space Coast. Space Coast was here through the thick and thin of it from the very beginning, and he is on a 3-hour earlier plan than us, so he was up early. Link to the new channel. It is, if you go to the YouTube main YouTube page, there should be a link there. There's a new channel. It should be there to there you go, right there. And if you haven't read my book, it'll take your mind out of all this true crime insanity. It'll give you a different perspective on life. Check it out. Best mods in the U.S. No doubt about that. Black Widow. All right, everybody. Love you, America. Love you, Idaho. And I got to say, the UK, the Republic of Ireland. And by the way, the person from Lesotho, Africa, emailed me. I was absolutely excited and flabbergasted. One day, we're going to do a live show from Lesotho soon enough, and I'll do it in a tutu. See you tomorrow, 12:30 for Phil, FIL, and PHIL, and then the second channel for this starting probably at 11 a.m.